और यू मकरर
May I be permitted to mention for inclusion of Group 9 application?
Mentioning upon notice?
Yes, Honor.
Are you mentioning upon notice?
I have annexed
Application?
application.
May I be permitted?
Group 9 applications, whoever have served prior notice, please give.
It is typical.
Applications, please hand over this.
My lord,
Okay, sir.
this is my
No,
My-
yeah, just
I haven't, it is an application, but in the original site.
Original site. Application.
Stay
Group
petition.
9. Group 9.
Group 9, Mala, electricity matters.
Have you given a notice to your other side?
Yes, Mala, this is the notice.
Original side क्यों नहीं?
Mala, once your lordship allows the mentioning, I shall coordinate it.
You shall?
I shall coordinate with your lordship's original side officers.
No, that is not. Let us see you give it over. Give the
Yes.
slip, we shall ascertain.
Lordship, my lord.
Yes, Mr.
My
Shah.
lord, is it
May I have
my
your
lord's pleasure to appear, direct the matter to appear tomorrow? There is some urgency.
Not tomorrow, we shall check up the list, how we see. Yes.
So the matter had appeared in your lordship's list on the 11th. Your lordship has been pleased to fix an appeal on the 25th. Well, at 25th, I'm in some difficulty. I'm mentioning upon notice. Well, Mr. S.N. Mukherjee is appearing for the other side. He has, my lord, asked me to request your lordships if it can be kept on the 20th or 23rd, if it's convenient.
20th of
20th of this month, well, 20th or 23rd. Your lordships have kept it on the 25th.
who is your other side, Mr.
Well, Mr. S.N. Mukherjee, my lord, his junior.
I'm assisting Mr. S. Mukherjee.
Primary fix আছে? Then we'll keep it on 25th.
25th, my lord, I'm in some difficulty. Your lordships have kept it on the 25th.
Oh, I see. Then we will keep it on 2nd July.
2nd July. I'm grateful.
Give the slip. Appellate side.
Yes, ma'am.
My lord, may my lord slip to mention especially assigned matter, my lord, for inclusion in the supplementary list, my lord.
So original side matter. Original side matter.
No, appellate side matter, my lord. Your lordship had taken this matter earlier. Direction for affidavit your lordship had given, but because of change of determination, it appeared before another bench, and that bench released the matter for.
Then why you are saying assigned?
But this matter has been assigned regular because of change in regular. Now this has been especially assigned.
May I mention the group 9 matter, my lord?
বলছে assigned বলছে।
My lord, due to grave urgency, my lord, I am mentioning this matter group 9, my lord. I am being threatened for the private respondents, my lord.
Sir, all your matters are extremely
lo-
urgent. Tomorrow you will
No, not tomorrow. Subject to lordship pleasure. My lord, it may appear on any day, my lord. At least it may appear, my lord.
give this
My lord, for inclusion, my lord, group 9 matter, original side matter, my lord.
application. Or
No, my
hearing.
lord, it's a fresh matter. Previously, Honorable Chief Justice have determination. Now your lordship have determination.
Give this.
This is a group 9 matter, my lord.
Appellate side.
The appellate side.
Are you mentioning upon notice?
My lord, this is a fresh matter, my lord.
It was never
It was
appeared earlier.
never appeared.
When
This
was the
app-
returnable date?
returnable date was 18th April 2025.
18th April. So what you are doing for so long?
Yet now the matter has not been appeared in the list also, my lord. We have mentioned it 3 times earlier. My lord, kindly keep any date as your lordship's convenience, my lord.
It was never heard.
No, my lord.
Have you served upon your copy of the application upon
Yes,
all?
yes.
Do you know who is appearing?
No, my lord. Then I have to take instruction, information from the department. my lord.
Hand over the slip, take information. Next week it all.
Again, I will inform them. Again, I will inform the respondents. Grateful.
Yes, call the list.
Me, it is the lordship. This is my appeal minute. There is a direction of your lordship in the last occasion to hand over the case diary and others. We have handed over. They have duly received, and accordingly a seizure list has been prepared, whatever we have given. Now, coming back to the,
So admittedly, you did not hand it over earlier.
no, earlier, no, admittedly.
Why?
Millet, they have going on the investigation, Millet, since we have challenged the Millet, the order, there is a two directions. One is to start the case and to hand over. Millet, we have challenged the Millet order in toto. Now, Millet, before coming to the order impugn, may I just pointed out two very
No, we
important.
will come, please, we want to know the reason.
Yes.
Order was of 18th April 2023.
Yes.
CBI files a report that even in 2025 you have not handed over.
Millet, the
is the
Lordship
explanation?
may recall in the first occasion, learned SG Millet had said that they have concluded the Millet investigation and about to file a charge sheet. So thereby, Millet, they have gone on their own independent proceedings. Whatever is there, Millet, whatever is there in our session, we have handed over today. Now, Millet, let us coming back to the Millet, the case. This is very, Millet, two questions, Millet, which is troubling me. Lordship would see, Millet, the first paragraph of the Millet judgment, which is page 118. No, 118. Sorry, 115, sorry. 113. Lordship would see in first two line, there are two writ petition has been shown. One is WPA 14678 of 222 and one is 7662023. Millet, this petition, the first petition has been filed by the same person with the identical relief of the second one. Now, when the second petition was filed, he has suppressed the entire things. We have, Millet, brought into the record of the court that this is the conduct of the petitions. Millet, they have accepted that yes, by mistake we could not. Now, the second very important question. Millet, the petitioner himself said that he has given a money to a particular person in lieu of the job. Millet, he has not lodged any complaint. Millet, the FIR has been started at the instigated of one Amrita Bapari. Millet, he, according to his desire and his submission, this matter was transferred to the CBI. He is not the complainant.
How you are agreed by the order?
Kindly, yes, I will show two things. Kindly come to the page 38, paragraph 38, I'm so sorry. There are certain, Millet, remarks has been made by which, Millet, the investigation was transferred to the CBI. Which is at page 189.
Yes,
May I read, Millet?
189.
189.
180.
129, sorry, 129. 129. না চোখটায় প্রবলেম হচ্ছে তো আমি দেখতে পাচ্ছি না।
Yes.
129, page 38. As already indicated herein above, the investigation officer HON'BLE has already shown extreme diligence and courage in conducting the investigation. This court is of the view that such courage and diligence may have fallen short when it comes to the principal accused. The fact in that case diary and those available in the pleadings definitely indicate nothing prevented investigation officer from seeking custody of the principal accused Taposh Shah after the compliances of the section 41A. The statement of the co-accused clearly equivalent the indicate of the court to role of the principal accused. Now, Millet, kindly pause here for a moment. Millet, the custodial interrogation, rather in the address, is the clear domain of the Millet, the investigation officer. Millet, Lordship has no, Millet, in the judgment of the Lalita Kumari, it is clearly held the arrest is not a mandatory thing. It is merely the domain of the investigation agency when and what manner they will investigate. kindly have a look into the paragraph 107 of the Lalita Kumari's judgment.
Which remark you want to obliterate? Which remark you want?
Well, kindly see, no, two things. One is the manner this has been handed over to the CPI. This cannot be treated as a precedent.
challenging the transferring the investigation to them.
Let I tell your lordship, I am also investigation agency. In a federal structure, I cannot say the manner this has been gone. Millet, I say the precedent should not be created the manner this has been gone to the CBI. First of all, the person concerned who is not a complainant, not as a de facto complainant, and coming up with an unclean hand.
We were told that you are challenging the order for expunction of certain
Millet,
adverse.
this is, yes, this is
What
lordship
about
may
the
recall.
state?
No, lordship may,
It has not come up in appeal.
investigation agency have come up.
He has filed the petitioner, this inspector of police anti-corruption has.
He is being included as a respondent number 5. The respondent number 5 is the applicant here in Milord.
Very good. He
Yes.
is not the state. He is an officer of the state.
Officer of the state, but it's a wing of the state, Milord. Kindly appreciate. Is a wing. Is
Does he individually handle the wing?
no.
Then
Well, kindly see.
he was impleaded as the investigating officer.
Investigation officer, but the appeal has been preferred by the ACB. ACB, Anti-Corruption Bureau,
By the inspector of police.
Inspector of the Police Anti-Corruption Branch
Yes.
is the post. Millet, he was there, Millet, in the initial in the.
He's not representing the Anti-Corruption Bureau.
I'm
He's
sorry?
not the spokesperson of the Anti-Corruption Bureau.
Certainly not, Millet.
He has come in his individual capacity.
Millet,
And that's where you started your appeal.
right.
You said, I want certain remarks against me to be expunged.
Millet,
That's all.
I may recall. Millet, why I have made that statement? Because of the reason the learned SG said that we have already filed the charge sheet. That is why there is no scope in that event. Since the charge sheet has been filed, I have no scope. That is why I made the submission that this is the same. Now, kindly see, Millet, paragraph 39. The court is mine in the note free from the doubt that the investigation officer's hands have been tied by the vested interest from the proceedings that the investigation and to take it in the full circle. Thereafter, the court is also noticed there are 3 other accused. One of whom is a personal assistant who's received not only salary allowances from the principal accused, but also as per the investigating officer's finding, handle cash transaction running into the several crore of the rupees. The letterhead of the MLA and his signature of such document have been disposed by the co-accused. There is substantial evidence and the reason for the investigation officer to have taken the principal accused into the custody. He has not done despite having wanted to do so. The court is also noticed another glaring aspect that the matter, although there are 3 accused who are not public servants, the state has not chosen to include any section of the IPC in the FIR. The IO does not appear to have been proceeded to do so, proposed to do so. There are other aspects of the investigation this court does not wish to discuss. Herein, it may prejudice both the prosecution and the accused. The aforesaid observation made by this court are only for the limited purpose of arriving at the findings as to whether the subject investigation ACB case number 3 ought to be transferred to the CBI or not. The observation made herein above should not be in the way to construct a final finding on the FIR. The truth will emerge only in the course of a fair and independent investigation. Such independent, effective, fair and sincere investigation is also a vital and essential preparation of the free trial. For the reason indicated herein above, the court directs that the ACB police station, ACB such and such, rate be transferred to the investigation. So, Millard, from paragraph 38 onwards till paragraph 44, the aspersion has been drawn against the officer that the manner he is being conducted, that is not fair enough. As per my understanding, may it only kindly consider this aspect, not to arrest a person. Can it be said that this is not going on a right way? May the investigation, in what manner they will go, that is the clear domain of the popular. That is the clear domain of the investigation agency. This has been clearly dealt in the 2006 7 SCC. Kindly see the paragraph 46 and 48, my lord. বলে দিচ্ছি। 46, 48.
Who is for the state? Who is for the state?
State, my lord, we had served, my lord, state have, he has to come up, my lord. May I come back with a fresh service in that event?
Mr. Chokku, what is the status now? Why you are not filing the charge sheet?
No, we have filed the report, kindly see this.
Yes, we have seen the report.
Yes.
Charge sheet is yet to be filed.
The principal accused who died.
He has expired.
And charge sheet was made ready but could not be filed. About which accused number 2, we have filed the charge sheet. There are several accused investigations going.
Accused number 2, you have filed the charge sheet?
Yes.
No?
So kindly come to the report.
Yes. Paragraph 18.
Paragraph 18.
Of your report.
That is about the other accused, that a list of details. Para 9,
Oh,
kindly find
necessary
para 9.
steps
Para
and-
9, kindly see para 9. Para 9.
Where is the charge sheet has been submitted, Mr. Chokku?
Just a minute. First Special Judge Alipur,
When?
17th May 2025.
17th May.
25, yes.
You filed this report on 13th May.
Yes.
17th May, you have filed the charge sheet.
Yes. That is what I find from the record.
You bring it on record. We do not know. You show us that the charge sheet has been filed.
May I handle?
So then, charge sheet has been, when is the next date of hearing?
26 June for taking cognizance of the charge.
26 June. It is before the sessions judge. Or?
Special Judge, First Special Judge Alipur.
জজকে দেবে দুটো ভালো বই দিই। CBI has not concluded the investigation, I would like to point it out very interesting things. Kindly take trouble to see section 8, Roman 2.
You don't understand your argument.
No.
Your argument is my officer was the investigating officer. Court has said that why didn't you arrest him?
Correct.
To that effect, you are citing a judgment that cannot tantamount to misconduct.
Obliged to Lordship.
You have
Obliged
to read the order in the entirety of it.
Yes.
Question of transference of the investigation was on the rudiments of some recording in para 38 to 40.
44.
You have not challenged the transfer.
No,
You are challenging, please remove this remark from the order.
That's it.
So you restrict your argument only.
That's it. But for the purpose of the fair and the transparent inquiry, investigation, I would like Lordship may takes it up, Lordship may reject my argument. Lordship, kindly see what is his locus. Kindly see section 8.2. No, Lordship, kindly see there are two things. Kindly have a look. Lordship may reject my submission. 8.2. 8.1.2 of the Millet Prevention.
When did you hand over all the documents?
Millet the 22.
22nd of
22nd of May.
What were you doing from 2023 to 25?
No, after the order has been passed.
Order passed in April 23.
18th April.
No.
That itself is a misconduct.
No. Lordship is saying the mother order which is under challenge.
Yes.
After that minute we could not because we have challenged the order.
Why? You have not challenged the order of transference of investigation.
In
You
fact,
have to explain to us what made you to withhold the records.
I have challenged the entire order. If your Lordship kindly take travel to
Entire
see.
order on individual capacity, we are not acceptable to accede to your prayer.
Very well, Lordship do not accept that.
So you have to show, we are asking a question to you.
Yes.
When the order was in April 23, what made you to withhold the records? There is no explanation on it.
No explanation. If I use give any explanation, that will not be very viable to this court.
So then we will reject your appeal.
No, Lordship may reject my application. Reject. Before that, Lordship kindly take trouble to see the two things. I would like to point it out. I am pointing out from the very beginning.
Mr. Sengupta,
kindly see two things only.
Mr. Mr. Chakraborty, on the next day, your officer will be ready with the order which is passed by the Sessions Court as regards cognizance. Which is passed
If
by-
cognizance is taken in the meantime.
Please intimate, you have to intimate that. Yes,
Would it be Lordship's pleasure to record one more thing? Initially, when the appeal was filed and prayer for stay of operation of the judgment was made, the division bench directed the CBI to file status report and hand over
The first line, my lord.
by reason of a typographical error, the now what are the applications, Mr. Bhattacharya?
My lord, first application is an application for stay, my lord, which was heard by a coordinate bench of your lordship's court on the 23rd of August 2023. It's a part of the application, my lord, page 18.
Yes, so modified interim order.
My lord, the thing is, by the order, initial order made by your lordship's court,
Yeah.
my lord, we have been
restrained from participating in any tender. in
Any
West Bengal.
tender invited by the government of West Bengal or any of the government organizations and such undertakings. Now, my lord, two things first. My lord, if your lordship kindly sees the debarment order, which is under challenge in the writ petition, my lord, please come to page 76 straightway.
What had been the this? Alright, sorry. Page
76 of the thicker one, the thicker volume of Can 1.
Have you served, Mr. Bhatt?
Yes, so I am representing the respondents.
You are for the
All the respondents, West Bengal Mineral Development and its office bearers.
প্রচুর অলরেডি সাবধান করে আছে একটু খুলে দাও page
76.
Yes, sir.
This debarment order, my lord, for 5 years, all related person from participating in further tenders of West Bengal Mineral Development Trading Corporation Limited for 5 years. Now, this was the debarment order which was under challenge in the writ petition. Now, my lord, this debarment order is in respect, my lord, kindly, this was perhaps, my lord, though it was pleaded, my lord, that aspect of the matter was not gone into. This debarment or whatever flows from my non-disclosure of a previous, my lord, blacklisting in respect of a tender which ultimately did not culminate in anything. It was cancelled. My lord, there were 3 tenders. 3 tenders floated by the WB MDTC Limited. My lord, we are concerned with page 93, which we have appended here. Yes, lordship sees, my lord, page 93. Kindly sees, apart from anything else, retender. Retender. Now, the previous tender where we had disclosed in a previous tender, this is retender. The first tender we had disclosed, that was cancelled. This was the second tender. This was also cancelled. This did not see the ultimate culmination. In a third tender in which we did not participate, ultimately someone has been selected. Now, because of the non-disclosure in this retender, my lord, kindly pardons me, my lord.
Why it is retendered?
Because the first tender was cancelled.
So on those terms, retendered.
On same terms.
Why was the decision for retender?
Well, that I do not. Well, for whatever, I am not questioning.
So you in the first tender you
I disclosed.
Huh?
I disclosed also.
Which was ultimately
I participate and I disclose whatever was obligatory on my part. Disclosure means the non-disclosure of which is complained of here was disclosed by me in the first tender. That did not see the light of the day, that was cancelled.
Yes.
Now, this is the retender. Now, during this retender part, I, for whatever reasons, may not rightly, wrongly, on whosoever's advice, I am not going, I shall come to that a little later. But prima facie, I did not disclose it. Now, this retender also did not culminate in any work order. I was not given any, nothing. it was cancelled. Third tender was called. Once again, retender. In that retender, I did not participate. And that ultimately gave shape to some work order.
So the third one was also a retender.
Yes.
So it is pertaining to the same
Same thing. By the same corporation.
Did not participate.
In the third tender, I did not participate. Now, pausing here for a moment.
Yes.
Traveling back to the Maharashtra issue. In the Maharashtra issue, what happened is I participate in a tender for whatever the terms was the tender. At the stage of consideration, I indicate to the Maharashtra authorities that I am not keen in participating, kindly cancel my bid. Without even batting an eyelid, they did not wait for the last date in Maharashtra in 2017. Without even batting an eyelid, they issued a letter of intent in my favor. I already informed them that had floated some tender in which I participated in
with which the respondent has nothing.
Nothing. Only subject matter of controversies in the Western
In that blacklisting, how many years blacklisting?
1 year. And that blacklisting, I was a 10% stakeholder in a JV, 90% was someone else.
Very good. Now what?
And that blacklisting was an offshoot of some decision of Western Coalfields, because at the stage of consideration of the financial bid or whatever, I chose to withdraw from the bid. That is the sum and substance. It is not for any other reason. Now, that was for a single year. In this, there are two clauses which I need to show your lordship. Please come to the impugned tender. Now, please see page 168 and 195. We are concerned with 7.8.3. And (195).
May I just interrupt for a moment? If Mr. Bhattacharya is arguing on the merit of the order of blacklisting, in that event, Lordship, I will ask for filing of affidavits. Because the earlier stay Lordship, in the earlier stay application was disposed of without calling for affidavits.
I shall show his submission.
This is a type of news, another stay application. The earlier stay application was disposed of without calling for affidavits.
Disposed of, let him show the order of disposal of when I go out of court.
The
appeal was admitted.
Appeal was admitted.
The appeal was admitted on papers.
What modification you are?
Today the modification is this order of 23rd August 2023, which pins me down to this extent at paragraph 8, page 19 of
West Bengal. You cannot.
We can't do. Lordship, now whenever I have pleaded that post this order, whatever tenders have been floated across the country in various states, various corporations have floated, this order stands in the way. This order of debarment for 5 years, my entire lock, stock and barrel, I am one of the stakeholders in the country.
But only in the state of West Bengal.
Yes, but that is operating as a fetter insofar as the entire country is concerned. And my entire business, lock, stock and barrel, is today stopped. These players are few in number. It is not that there are 100 players. my lord, some of us, my lord, my contender, my rival in trade is getting, my lord, is being blessed with work orders. And my lord, kindly visualize, I have been blacklisted in respect of a tender, in respect of a selection process. The selection process did not see the conclusion. Non-disclosure in such selection process cannot be, if at all, whether such non-disclosure would be so fatal so as to debar me for my entire life.
So have you disclosed that
Yes,
which are
yes.
the tenders you are wishing to opt for?
Yes,
In
in
the
this application in Can 2. My lord, I have pleaded it from paragraph 6 onwards. Paragraph 6 onwards, page 6. In fact, there was a collateral challenge thrown to one such order before Gujarat High Court. The Gujarat High Court's order also says that because of this,
Which page?
the page 6 kindly comes to page 6 of the present application.
Page 6. Yes.
My lord, of the Can 2, kindly see Can, the second Can, that's the thinner one.
Can-
But applied for composite mechanized mining work for production such and such,
Better,
including
better.
paragraph 6, page 6. Paragraph 7,
That was for
yes, and
21.
yes. And my lord, by a communication of March 5, 2022, my lord, they have informed me, my lord, page 7 kindly sees. In further communication addressed by the tendering authority, it is explicitly stated that the reason for rejection of the bid is the debarment issued by WB MDTCL. So this is, my lord, by a different state, Taldi in Orissa. Then again, my lord,
That story is over now.
no, that story, my lord, with respect, my lord, this debarment order,
We understand. We are
this
wanting,
debarment is restricted to WB MDTCL work orders.
understand. We are wanting to know from you which tender you are now intending to participate.
My lord,
but you
whenever
are not being able to do due to this.
intending to participate, my lord, if any tender is floated, one of the clauses will be, my lord, this whether I have been, my lord, restrained or blacklisted by any organization. The moment I put that information, what happens is, my lord, the tendering authorities are relying on this debarment order, which I invited my lord's kind attention to, and are saying that because of this debarment, you are precluded from participating. The Gujarat High Court order is there. I am not coming to that, but Gujarat, the same issue was there. In Gujarat. Why? Because post this debarment, which I invited, page 76 of the thicker one, you know, page 76.
So you are wanting an observation from this court that that order was limited to the
to
state of
WB
West Bengal.
MDTCL at best,
And
and
so
not for the entire country. That order, if at all, you know, I'll tell your lordship, you know, in the first round, when I had appeared, far as the last observation following from your lordship, that this order of debarment will not preclude the appellant to participate in any other tender, lordship, I will not stand in the way, because we have restricted
no,
the
no, participation they will do, but their tender will be cancelled due to this.
lordship, kindly make that observation that this will not stand in the way. Lordship, to that I have no objection, because
All right.
my client has debarred the appellant from
So very good.
preventing our future tenders for a particular period.
So very good. We shall make the observation that this will not This cannot be cited in by any other tendering authority.
I have no difficulties to that. Kindly take up the appeal for hearing.
And we will take up the appeal for hearing.
Yes. To that I have no objection because I cannot go beyond the order what has been passed by my client. My client has restricted the appellant from participating in its future tender for a particular period. So I cannot prevent the appellant from participating in any other tenders. Which part? Which part you are trying?
So where is that specific in modification you are wanting?
The specific modification, in the
You have
application.
not stated in your prayer.
So the last portion of the
I
prayer.
have specifically stated in the prayer that since this order is not helping me, the order initially passed in the appeal, to the extent of limiting it to West Bengal, is not.
Prior to this 23rd August, any order was passed?
No.
This was the only
23rd
order.
August 2023, the portion of
But
the.
there was an interim order, it says 4th of July 23 in the 23rd August order, third paragraph.
Blacklisting order dated.
No.
Had the benefit of an interim order dated
এই-
4th
এইটা কি
July. Oh, that was by the single judge.
না 4th July টা কি?
4th July টা হচ্ছে first writ petition, first round of writ petition.
Had the benefit
So the 14 July order is the order of the Honorable Single Judge.
14th July.
Yes.
In the writ petition and interim order was passed.
Yes,
Milord.
yes, 4th July in
Milord,
order and the writ petition.
In the writ petition.
Where is that order? 4th July.
I'll just show you. I don't have it just now. Type it খোল না।
আর page 50 দেখাও এখানে page 50
ওকে বলো না, আমাদের লোকটা আছে না,
page 80 টা দেখাও।
এই শোনো, এই WP just a point. কত কথা?
মেন অর্ডারটা
Main order টা পুরো। Yes, we got it 4th July.
4th July order.
এটাই তো।
The 4th July order, I can read it here.
What you want?
No, I wanted to show your lordship your lordship has seen paragraph 8 of the initial order made by your lordship's court in the appeal. That has been interpreted by another high court. Please come to page 50.
The Gujarat High Court order.
This is of your same clients.
Yes. Because page 50, paragraph 5.5, kindly takes the trouble to come to 51, 50. An advocate for the petitioner referred to the order of the competent court. However, we are at a loss to see any orders staying blacklisting of the petitioner by WBMDTCL. Still, however, reading paragraph 8 thereof, it is submitted. And since they are precluded from participating in any tender invited by government of West Bengal or any government organization, public sector, such and such of the state, it is a stay of blacklisting so far as it relates to participation in other states. They can participate in any other state. It may be an interpretation of an order passed by the competent court by the learned advocate for the petitioner, but in no terms it reflects the order blacklisting debarring consortium partner is ever stayed by that court. On the contrary, paragraph 5 thereof reflects that even if period of blacklisting is over, the stigma will not vanish if any condition prescribed in the notice inviting tender is disclosure of any other order of blacklisting. So, my lord, today
it was a consortium partner.
Yes.
Not your case.
My
I am the consortium partner.
I am the consortium partner.
So you are a joint
Please see
venture.
page 23.
My Gujarat tender, I participated.
Gujarat tender, the writ petition was carried to your lordship's court by
Okay,
DECO
BGR
consortium,
Deco
of which I was one of the parties,
the lead party then.
lead party.
And this also is Deco.
Well, two things I will be humbly requesting your lordship. My lord, I am
Mathar order ta? Huh?
Submitted that all the records are there in the writ petition. So in the writ petition, it was no affidavit was called for.
So very good. We will dispose of both these two applications.
yes.
Yes, we can dispose of.
And giving them that they would be able to participate in respect of any other concern.
Yes. And this order of debarment issued by WBMDTCL will not stand in the way.
This is
So
the
you
one.
want non-debarment
No, I
respect of
want
all
the-
tenders outside West Bengal.
What I really want is that, if your lordship kindly, let me just two additional facts, need to be told. First additional fact is this debarment order at page 76 of the appeal papers that your lordship is looking into has a history, has a background. What is the background?
Mr. Bhattacharya, we will hear the appeal. You can argue on that.
Kindly, instead of
We will extend you
But
the
the order-
benefit. We will extend you the benefit as granted by the writ court in the interim. 4th July.
very well.
Huh.
4th July order.
এই যে এটা হচ্ছে
As if there was no blacklist.
হ্যাঁ yes
এটা হলে হবে?
হ্যাঁ হ্যাঁ
So we can dispose, we can dispose of both the, Mr. Saha, we can dispose of both the applications.
Yes, what's your
And we
application?
will ask them to file the paper book recording
Yes.
that you have not used any
Order
opposition
আছে,
since
the
all
writ
the
petition.
materials are there in the writ petition. They will file the paper book, we will hear.
No blacklisting.
as if there is no blacklisting, as if there
Very
is no blacklisting, yes.
That will help.
And fix a date.
So then it
Yeah,
will be subject to the result of the appeal because the interim
Yes,
order
yes.
says
No problem.
Yes, yes.
there is
Subject to
That will be subject,
Lordship.
this order which we pass will be subject to the result of the outcome of this.
the appeal, isn't it?
for the
হ্যাঁ, সে ঠিক আছে। Fix the date.
The instant appeal from an order of July 14, 2023
নে ভাই এটা আমি সব ইউজ করতে পারবো।
একটু অসুবিধা।
হ্যাঁ, হ্যাঁ।
Mr. Bhattacharya, that we are thinking stigma will remain. Stigma. Anyway, it's your decision. Yes. Item number
4, my lord.
4. Yes.
I am for the appellate, my lord. Last occasion, my lord, CSC and my lord, filed the report. Exception was also filed by my learned friend, my lord. My submission is that, my lord, they have, my lord, produced the my lord, photograph. That photograph is my photograph, my lord. I am constructing the structure, my lord. They have taken it, my lord, submit before your lordship, my lord. If your lordship again, my lord, directed CSC, my lord, to visit the premises, my lord, ascertain whether who is the possession, my lord. They are never possession, my lord. Recently, my lord, structure was made by me. So, my lord, the port trust filed an application in connection with the suit, my lord, again, for constructing the structure, my lord, against my client, my lord. They have not connected with this premises, my lord. They have not produced any document. He is in possession of this property, my lord. Initially I am the leaseholder, my lord. Lease was not extended. They have floated a tender. I filed a suit, my lord. Order was passed in my favor, my lord. Against that, the port trust filed an appeal. Appeal was dismissed. Thereafter, suit is pending and my injunction is going on. I am in a possession, my lord. They have not submit any paper, my lord. They are in a possession, my lord. Kindly direct them to produce any document how they came into the picture of this, my lord, possession of the property, my lord.
You are Dhananjay Tiwari.
My client, my lord. I am the initial
Are
leaseholder.
দাঁড়াও।
Sorry.
So pursuant to the order of 18th May,
Yes, my lord.
they filed a report.
Yes, my lord.
Where is that report?
Report, my lord. This is the report, my lord. Already in record.
My report, my lord.
Exception you have filed to the
Not
report.
I have
am not
filed the
filing
exception. I have
filed my lord.
for the
I
response
am
number 1.
accepting the report, my lord.
And
I am accepting the report.
I am telling your lordship, my lord, if 2023, my lord, inspection was conducted. At that point of time, my lord, report was prepared, and thereafter, as the matter was not appeared, now, my lord, 2025, that report has been filed. Now, my lord, subsequently, there is a change of circumstances as it appears from the exception from by the respondent, writ petitioner, my lord, respondent before your lordship, that there are some construction. My lord, whether the construction has been made by the appellant or the respondent CSC can't decide this.
Yes.
Can't decide that, my lord. In 2023, what we found, we have mentioned in the report, my lord.
If your lordship desire, I file a supplementary affidavit annexing all the documents regarding my lord, the tender, my lord, the contractor appointed by me, and my lord, materials collected by me, and also all. If your lordship desire, I file a supplementary affidavit. And also, my lord, they have my lord, broken my gate, my lord, so I file a GD also. Also, I, my lord.
অম্লান
দাদা আমাকে ডাকছে দাদা
এটাই আগের ম্যাটারটাতে ঢুকিয়ে দিবে আগের ম্যাটারটাতে
In the appeal, first order.
Are you two related? Are you two related?
Yes, yes. My instruction is that we are not in this generation, my lord, but then our uncles were, my lord, possibly related. She was absolutely right. I just take, my lord, 2 minutes. I, my lord, because I claim to have been in possession, I apply for an electricity connection. Because they come and object to the electricity connection being given to me, even after there is an initial inspection that takes place, I file a writ petition. In the writ petition, my lord, they file an affidavit in opposition claiming to be in possession of that property. But at the same time, in the same affidavit in opposition, they say that they have inherited a suit from their predecessor in title, which was filed against the Kolkata Port Trust. Now, in that suit, there in an application under Order 39, Rule 1 and 2 filed by my learned friend, there is an order of status quo, which apparently the KOPT had assailed by way of a 39-4 for vacating. 39-4 gets dismissed as per their own assertion that injunction order status quo in a suit inter se between them and KOPT that is subsisting till date. That was the unequivocal submission they make before the single bench. Before the single bench, we show that we are in possession because of certain documents, my lord, that's all a part of the writ application. They are unable to deny that. So, my lord, the learned single judge holds that today the writ court will not cause a physical inspection because that would essentially tantamount to a trial. Whatever is required to demonstrate physical possession or, my lord, according to the Abhimanyu Majumdar judgment, my lord, settled possession, I have been able to demonstrate before the court. So, even if I'm an illegal occupant, I would be entitled to electricity. If they want to dispossess me from that property, they will take appropriate steps in accordance with law, and grant of electricity as per Section 43 of the Electricity Act will not tantamount to giving any civil rights in my favor. And the single judge disposes of the writ application, directing the CAC to grant electricity in my favor. Now, the appellants here in Malot challenge that order before the Honorable Division Bench on the sole count that, number one, I have not been able to demonstrate physical possession over the property or settled possession of the property. So, when this matter had come up for the first time, Malot, the Honorable the Chief Justice directs the CESC to cause an inspection to be done without letting any of the parties know, and then find out who is in actual possession. This order was passed in the year 2023. The CSC, in compliance of that order, sees that there is nobody in the property, neither me nor them. So there is no finding with respect to the possession. But with respect to structures, the CSC in one line, my lord, in the report, which I'll show to your lordship, holds that there is no structure. Now, that report is made over to me for the first time in 2025 because the matter did not come up in the interim. So when it comes to my notice, I see that there is a structure because I have made these constructions. So I, by way of an exception, show that there have been constructions which have been made at my instance, and I file the exception. Today, the appellant comes forward and says that whatever photographs, and he makes that submission today, that whatever photographs have annexed, those are all photographs that he should be annexing because he has made those constructions. That goes contrary to their submission that there is an order of status quo. No. He says that there cannot be any construction done because till date there is a status quo, and he's annexed that.
Is in possession of the property.
So, as per the CSC's report,
so nobody is there.
So as per the report filed by the CSC, they could not find anybody on the date of the inspection.
Because that was a surprise.
That was the surprise visit. I'm not challenging that. That bit I cannot challenge because
either you are in possession, not he is in possession.
He's in possession. So well, the construction is done at my instance. He could not have made.
Nobody will get connection.
Yes.
We will make the
yes. Lord, we have.
Either you will get, not he will get. Let it be decided by
in
the
my writ application. I bow down to that one. But in my writ application, no suit against me. I am not a party in any suit.
If they
will you keep quiet, sir?
I am, number one, my lord, I am not a party in any suit. Number two, my lord, for settled possession, which we had demonstrated before.
Now, by virtue, if today there is a genuine dispute, their CEC notices that it is a vacant plot of land with a structure, nobody is in possession.
Which is
so
why
there is no requirement for electricity in that.
No, there it is not a vacant plot. That is my sub, which is why I filed the exception. Lordship takes up my exception only once, my lord. I have annexed the photographs.
No, it is your contention that you have constructed.
Yes.
It is their construction that I have constructed.
It cannot be because it's contrary to this.
We are concerned with the possession aspect of it.
Yes, yes, my lord.
Neither you nor he can satisfy that you are in possession.
But I'll show from their pleadings. My lordship takes up 116 of their
No,
appeal.
their pleadings won't help you. You are saying that their possession needs to be falsified, since that we were been in violation of other proceeding interim order. But there is no existing order in your favor. You are claiming that I have entered into the property, I am in possession.
Prior to the filing of the writ application, which is why
Very good, but the court called for an inspection report. Inspection shows nobody is in, so file, go on
Nobody-
fighting.
my lord, the
against
report
yourself.
only, which is why, my lord, I argue, the report, my lord, only says,
How are you in possession? What's the basis?
my lord, it's come down to me.
As
My lord, as,
lessee, owner,
Yes, yes, yes.
what is
as,
the basis?
as a,
Yes.
As a lessee,
my lord, as a lessee. That's my instruction that I've received.
your head will fall off. Don't shake it so hard. Sit down, sit down.
I am, my lord, I am contending that in the capacity of a lessee.
To us, what is the basis of your possession?
Lordship, kindly, my lord,
What
takes
is the
up,
basis of your possession?
Lordship, kindly takes up my
What
writ
is the
application.
basis of your possession? Or
I am the
your,
lessee. I am the lessee.
show me,
Yes.
show us the,
Lordship, my lord, kindly takes up 84 of their appeal one.
Kindly see, my lord, the commissioner report, my lord. Commissioner report in connection with the suit. I am filed a suit, my lord. Initially, lease was granted for 15 years. Thereafter,
show us the report.
yes, my lord.
Show us the report.
My lord, kindly see the page 32, my lord. Page 32 of my stay application. Commissioner report.
My lord, I stand corrected, my lord. I stand corrected. It is not in the capacity of a lessee. In fact, my lord, I have only pleaded that I'm in occupation. So my contention, in fact, before the writ court was also that if I'm an illegal occupant under 43 of the Electricity Act, I'm still entitled to electricity connection. If they want to dispossess me, that would necessarily have to be before a civil court. In fact, I annex documents with respect to my trade license, all that the learned single judge has taken into account, my lord.
What, page 32?
You have got the exception. You have got
Not-
the exception.
Yes.
Huh?
Yes.
Opposition file. Has the order impugned been stayed in appeal?
Yes.
Huh? It has been stayed.
Yes.
But the order of the Honorable Chief Justice, Your Lordship C.
Where is the stay order? Good.
My lord, kindly come to the order dated 18 May 2023, my lord.
Oh, the order. Hey, file your paper books. We
Yes,
will hear the.
Yes, my
My lord, may I just make one small suggestion, my
We
lord?
will hear it.
Yes, yes.
Let him file the paper
I'll not stand in the way of that.
incorporating the report as well as the exception.
I'll not
filed.
stand in the way of that. I was only on the point, my lord, one limited point, that with respect was there. I understand, my lord, that there's a question that arises before this court, my lord, with respect to who is in possession. That bit is there from my exception and the report filed by the CSC. The paper books would not change that much. Would it be your lordship's pleasure, my lord, to direct for another inspection in the presence of both the sides? I'll be able to demonstrate, and that will be there featuring in the report itself that I'm in possession, because I have made
Possession
that
has
construction.
arisen.
In fact,
It's
the
no-
appellants will not be able to enter the property.
It is the contention that neither of you two were in possession.
No, they said nobody was present. They don't return a finding on the possession.
Right.
On that particular day when CSC or the officials of CSC go, my lord, that nobody was present. Lordship kindly
So
takes up the
possess-
report once, my lord.
fresh inspection will not serve any purpose.
In the presence of the sites, we'll show that the
Both of
constructions
you
are in
will
my
go
end.
on fighting,
They will not.
and the CSC will not be able to go into those documents.
CSC will just return a finding on that respect. That they will not be able to enter the property itself, my lord.
এটাই তো খেয়াল আছে না? হ্যাঁ, একটাই খেয়াল আছে।
You've heard the parties.
May please, your lordship, I am for the appeal.
Who is your
I
other
have
side?
served no one. Let it be tomorrow. I have served, but no one is appearing.
Not today. Yes.
Partition 7, my lord.
There are two appeals, one by my client and one, my lord, one by my client and one by the respondent. My lord, my appeal is number 7. My lord, that arises, my lord, out of the contempt with respect to, my lord, the order passed in my lord, my writ petition, which has been challenged, my lord, by the other side in item number 6. So item number 6, my lord, will actually take care of, my lord, item number 7 as well. Because I say, my lord, if this order stands, in contempt, the High Court could not have changed the order which was already passed, my lord, in the writ petition.
No, writ petition was, who was the writ petitioner?
I was the writ petitioner,
Bimal.
my lord.
So you obtained
I obtained an order saying that my possession should not be touched by the private respondent and the police will look after it.
Very good. Against that,
They have preferred
compliance, you preferred a contempt.
a contempt application. In the contempt application, suddenly, my lord, a dispute arose As to, my lord, with respect to my rights, there is no dispute. With respect to the identity of the property. Now, in that, the honorable judge said that this has to be gone through to the civil court. The civil court takes care of whatever it is. But my possession was never disputed by anybody, at least with respect to a part of the property. So that
his
has to be
appeal is
protected.
against the parent order.
Yes.
So if the parent, if he succeeds, then
Then this goes.
Yes, paper books are ready.
No, my lord.
My lord, I am with him. My lord, I'm not.
Stand on that side. I thought once that he's with you.
It was earlier hard.
My lord, it was before the honorable the Chief Justice. It was heard once.
So you serve a notice, we take it up 2 weeks after.
Mr. Shane was appearing, my lord, at one point of time before the Shakho Shane.
এটাকে তাহলে আছে কত তারিখ 16 তারিখ তো keep it on 2nd July you intimate your answer.
So ওরা যদি না appeal করে, we'll prefer. I'll give them notice.
2nd July you intimate your answer.
I'll give them notice, my lord. If they don't proceed with their appeal, my lord, I'll move with mine and whatever happens.
Yes.
My lord, your lordship is passing an order so that, my lord,
দরকার
the only second. only 2nd of July, my lord, your lordship is.
Please give a notice.
I'll wait.
Yes. 8.
I appear for the respondents.
Your Lordship, learned advocate Gaurav Das is appearing for the appellant, Your Lordship. I'm praying for a short passover as he's engaged in court number 8.
Not this week, yes. Next.
Lord is keeping his next week, my lord.
Or we keep it on 3rd July. You are
As
for
he-
whom?
I am for the private respondents.
I may
3rd July.
I may
Yes.
pay for the state respondent, Lordship.
Yes, next 9.
Grateful.
I appear on behalf of the respondent writ petitioner.
Reply 5.
Yes, ma'am.
Reply 5.
There was a section 5 application. Affidavits have been filed.
In section 5?
Section 5, because 274 days, 274 days delay. Only one thing I will be only indicating to my lords, subject to what falls for my lords kind consideration, that in the section 5 application, kindly see paragraphs 13 and 14.
Their application, na?
Yes, yes.
Yes, our.
Affidavit in opposition on behalf of writ petition.
Position.
Yes. Yes.
My lord, delays of my lord 238 days. My lord, at the time of calculation, what happened, my lord? The 30 days time which is granted for filing of the my lord appeal was not excluded. My lord, we have taken the stamp reporter's report. My lord says it is excluding that 30 days. It will be 238. So my lord, actual delay was my lord 238 days. My lord, what happened in this instant matter, my lord? There was an my lord, proceeding under the for police inaction. My lord, the allegation against the my lord, the writ petition was filed on the allegation that the the private respondents, being my lord, my clients, are disturbing the cultivation of the petitioners, which on the land which they have admittedly got by a in lieu of a partition suit. My lord, partition suit was filed in 1995. The ended in 1995. The belief.
You are challenging which order? 13th
My lord,
August?
13th.
Yes.
13th order.
Miller, there was only a indication of demarcation of the property. Kindly say.
Already been divided. No. কোথায় গেল? দেখি তো
What prejudice, Miller, will be?
Mr. Bhattacharya.
I'm sorry.
পরপর অর্ডার গুলো কোথায় আছে একটু দেখান। এই যে 87 থেকে শুরু।
Yes, Mr. Dhol.
My lord, what happened in this matter, my lord?
You are the Nimai Mondol.
Nimai Mondal and others, my lord, the private respondents, who,
So,
according to them, is
the
disturbing the cultivation.
writ petition was filed in the year 2017.
70.
There was an order passed in 2018.
Yes.
Yes. My
So
lord,
was that
kindly seize the section 5 application, my lord, at page 87. 87 onwards. My lord, the respective orders.
Page 87. You are in my
Section 5. Section 5 টা হবে।
Miller, the final order subject to correction that your lordships will be pleased to find in the.
No, my lord, it is very much
come
required.
back to you.
কেন পেন্ডিং আছে? কেন পেন্ডিং?
তুই অতিরিক্ত উত্তেজিত, বারবার বলছি উত্তেজনা কমা।
Yes, Mr. Dhol.
My lord will find from all the orders, my lord, kindly sees there is, my lord,
Which order?
first a report orders
order?
passed in this, my lord, the writ petition. My lord, first, my lord, kindly turns to the page 87. Page 87 of the, my lord, section 5 application.
Yes.
My lord, here, my lord, kindly sees it is very much relevant. The learned advocate for the state, on the basis of a written instruction, submits that the police has inquired into the complaint and non-FIR prosecution was submitted on 107 or 116 of the Criminal Procedure Code before the judicial magistrate. The police are requiring adhere to the order passed by the civil court. The petitioner has been put into possession in execution of a degree passed by a civil court. The police authorities are therefore directed to ensure the protection of the life and property of the petitioner in consonance with the degree passed by the civil court. In such circumstances, a report is called for from the respondent number 6. Such report, the respondent number 6 will state that steps taken in police in adhering the degree of the civil court in protecting the possession of the petitioner.
Very.
So, my lord, there is no direction for any demarcation. My lord, kindly sees the next order.
Has been put in possession by the civil court decree.
Yes. And now, my lord, my submission is, my lord, from it will appear from all the orders passed that there is no order for directing the BLLRO to demarcate. But my lord, it's the
Demarcation,
final order.
Mr. Dhol, demarcation, why will you? There was a civil suit. Decree was passed in his favor. Decree was executed.
Yes.
He was put in possession by the bailiff.
Yes.
So his possession shall not be protected.
No, I do not, I do not, my
So
lord.
demarcation, we are not concerned.
No,
The
my lord,
police
kindly-
authorities are under an obligation to comply with civil court order.
My lord,
Are you disputing that he was not in possession?
he is in possession, my lord. What I am disputing, my lord, what I am disputing, my lord, kindly sees the page 105, the order impugned. Why I am
paragraph to
very, since my lord has got 105, since the writ petition was filed in 2017, a direction was passed into the officer in charge of the local police station so that the petitioner retains its possession of land as demarcated by the BLLRO Tehotto. This is, my lord, totally, my lord, BLLRO Tehotto has never, my lord, demarcated. Palashipara, Nodia, by an order dated 9th of January 2018. I direct that till the BLLR
reflects that there is no complaint, but the issue relates to demarcation, which is the domain of PLR, who will act in accordance with law for the purpose of demarcation, if any. পরের প্যারাগ্রাফে রেকর্ড থাকে demarcation হয়ে যাচ্ছে। কেন
Why demarcation is required, Mr. Dole?
My lord, we have not stated, my lord, it is a court order. And what happened, my lord, after this order, the court, my lord, BLLR gone to the place and he started deviating from the earlier possessions.
Was passed upon OC so that the petitioner retains the plot which was demarcated by BLR. It was already demarcated.
Yes, that is my case, my lord.
Demarcation had already been done.
Demarcation has been done by the my lord civil court degree. The
Then
bailiff.
what is your problem?
My problem is, my lord, on the basis of this, the petitioner has got this, my lord, order from this court without any prayer, without impleading BLLRO as a party. He was not a party before the proceeding.
Second paragraph observation was
And
on the
now why-
basis of a report filed.
What
the basis of a report so submitted by the learned advocate for the state. On the basis of that report, it was court observed that it report reflects that the issue relates to demarcation, which the state said.
My lord, but that has already been demarcated. My lord, kindly sees the
So let us
petition.
understand. Court called for a court first and passed an order on 9 January 2018.
Yes.
What was the order? Officer in charge said that petitioner was never in possession.
Yes.
Next, court observed that there is a civil court decree, the person is in possession.
Yes.
This was 2018. This was not disputed by you till 2024. This order was undisturbed. 2018 order continued till 2024. Now your appeal, your stand is that it is their claim that the property has not been demarcated.
No. They have stated, my lord, in the writ petition, my lord, kindly sees, they have stated that the property is demarcated in the partition suit. We have been put into
Taken
possession.
Yes.
We have been put into possession. My lord, why this, my lord, this report has been probably coming from the state because they are claiming some portion of our property where the report has been given that the petitioners are not in possession. My lord, by this demarcation, my lord, the later on demarcation order, my lord, which directed demarcation, by this directed demarcation, my lord, they are now encroaching upon with the help of the BLLR, they are encroaching upon our land, which has been already demarcated in 1995 degree.
In the decree,
In the
you were a party to that suit.
Yes, we were party to the suit.
So show us the decree in the suit.
Degree আছে তো? First time. My lord, kindly sees the degree which is 90. এটা ইয়েটা ডিগ্রিটা কোথায়? My lord, the Order, my lord, kindly see that page 19 of the. They have awarded in their my lord writ petition, my lord, which is annexed to the
Final partition decree, my lords will be pleased to find from page 33
We
to
will come
51.
back to you, Mr. Bhattacharya. Let us understand. We'll come back to you. Yes.
আরে আমাদের কত এটা page 71, my lord, page 71 of the stay application, my lord, we have section 5 application. This is the writ petition we have annexed. This is their averment. Page 71, paragraph 7.
Paragraph 8 table. Ownership of distributors through relief by demarcation. They are trying to cover it specific.
Page 71 আমার section 5 application.
অ্যাপ্লাই করতে পারবে এটাই বুঝতে পারছি
ভুল করেছে আর কি। ক্লিয়ারটা কি দেখি?
Yes, my lord, kindly see the print. At page 81.
Yeah.
Where is this 30th October complaint?
30th October complaint by post, 15 November refile.
কিন্তু demarcation
False complaint refile.
ডিভিশন বলে আমি একটা কমপ্লেন করেছি সেখানে আছি
protect my possession.
এই যে দেখো পেজ 81 police of Kotlin by taking cognizance against Atul and then for causing continuous disturbance and wrongful criminal intimation harvesting in respect of 5 points.
By this order, my lord, what they have done on the earlier occasion, my lord, it was submitted before your lordships, my lord.
Now, where is this report? State filed a report.
The report has not been given to us.
This report was filed in the writ court. Where is the writ court report? Page 105, order of 13th August.
That writ court's report, my lord, we were the respondents in the writ petition. We were not given the report. That was filed probably in the court.
Acha, can you show us the complaint they submitted? Complaint to the Tehotto police station? That is on 30th of October 2017.
What number page? That is, my lord, kindly sees. Huh? কোথায় সেটা অ্যানেক্স করেনি ওরা রিট পিটিশনে? আমি দিইনি কেন ওটা? ওটা নেই? Page 74. Thank you. My lord, probably, my lord, that was not annexed. My lord, page 74 of the writ petition.
Yeah, just no such direction was issued. Appellant. Question of order of any demarcation does not arise. Create fresh.
আচ্ছা আচ্ছা তো অ্যাপেলেন্টের এটা দিচ্ছে স্টেটেড আগেও বলেছি অ্যাপেলেন্ট স্টেটেড
এই যে এটা show no such detection need to be satisfied.
এটা বোধ হয় স্টেটার করতে বলতেছে পাঠানো
এই যে বলছে এইটা ওর বক্তব্য ডিমার্কেশন অর্ডার
For the purpose of demarcation, আমরা যা পাবো। Second page.
PLR would be like no the part person who creates so that the details the just demarcated PLR which are deployed and maintained by
প্রতিটা
last demarcation was held on the end of view doesn't possess the matter raised in CB. Demarcation was completed then, 21st of May.
My lord,
Defined from the state report.
they have visited, my lord, they tried, my lord, they tried to demarcate, they actually what they are trying to do, my lord, they by this order, my lord, they are now encroaching our possession of lands, which has been possessed by us in terms of that civil courts degree. Partition degree. Now, so my lord, the first report stated that they are not in possession of that period. My lord, my possession, according to the civil courts degree, my possession of land, how they can be in possession? Now they are saying that now see we are not in possession. If there is a case, my lord, that he has lost the possession, where is that
Yes, Mr.
stated?
Bhattacharya.
He has to go before the civil court.
My lord, first of all, I would be drawing to my lord's kind attention
So
about
why did you pray for demarcation?
My lord, I just tell you, lordships, kindly permit me 5 minutes time. Now, my lord, first of all, your lordship may kindly consider the preliminary decree. The preliminary decree passed in connection with the suit for partition that my lords will be pleased to find from page 27 to 32 of the application for stay.
Stay.
27 to 42 of the application for stay.
What you are showing?
I am showing, my lord. Kindly see that this suit for partition was filed by my client. Starts from page 27. Now, the relevant portion is at page 32. The preliminary decree. The suit be decreed on contest in the preliminary form against defendants number 11 and ex parte against the remaining defendant. Page 32 of the application for stay.
My lord, stay application has been referred. My lord is probably seeing the section 5 application.
Section
5 we have also annexed.
Oh.
But my lord, my learned senior friend is referring to the stay application.
Page 32.
32.
Yes.
The suit
So
be
this was suit between you and another versus
yes,
other.
between the particular my lord family members, Sadhan Kumar Mondol and Lolit Kumar Mondol. Now, my lord, this partition suit, my lord, when the preliminary decree was passed, my lords will be pleased to find at page 32. there was a declaration that I will be entitled to 7/10 share, 10 share in the total suit property. Then the partition commissioner comes, partition commissioner, my lord, he files a report, then comes to the decree at page 33. Final decree, lordship may kindly come to page 44. Instead, I do not, I just shorten the issue. Page 44 is the final decree. That is, this has been submitted before the court in the judicial stamp paper. Page 44 has my lord got it, my lord?
Yes.
Now here, my lord, the particular, my lord, the shares of the particular persons have been indicated. Now, what is the trouble going on? The trouble is that, my lord, in spite of the particular passing of the final decree, which starts from page 44 to, my lord, it is at, it ends at 63. Now, my lord, not 63, 62. Now, my lord, it appears, my lord, that there was endeavors taken by private respondents insofar as a writ petition to grab or to, my lord, create disturbance in the particular land of the petitioner. Then for this, he filed a complaint before the officer in charge. Now, as your lordship was asking the query of my lord, that where are the complaints which you have filed before this? My lord, this has not, because this application for stay has not been filed by me. Therefore, my lord, I can only produce a copy of the writ petition. Even what has been done very, my lord, if I may say so, my lord.
No, we are intending to dispose of the entire matter.
Yes, and my lord, I do not find, subject to correction, that there is any particular illegality and or infirmity.
Writ petition was yours.
Mine.
Why did you ask for demarcation?
That is,
I did not ask for demarcation. Kindly see, my lord, the prayers in the writ petition.
Prayers for
Prayers in the writ. No, I say, my lord, your lordship may kindly consider that the pleadings in the writ petition or the prayers in the writ petition has to be gone into.
It was on your, then you have not come up in appeal against this.
No, I have not, because my lord.
So then you ought to have said that I did not pray for demarcation, finished.
No, I say, my lord, I only say one thing. Kindly see, my lord, page 89.
No, we will set aside the order. We will say that the possession to be, the portion over which you have been put in possession and the portion upon which they have been put in possession, that will be abided.
And therefore, the particular, my lord, the problem will continue.
No, the civil court is there.
Kindly see why I have filed the police inaction petition. Miller, kindly come to page 89.
Protection has been given to you.
Page 89. For a second, Miller, kindly come to page 89.
Yes.
A writ in the nature of mandamus directing the respondent police authorities. I did not, Miller, say anything about the possession. I say, Miller, about the disturbance, directing the respondent police authorities and their subordinates and each of them to forthwith take necessary steps by taking cognizance of the petitioner's complaint dated 30th of October 2017.
That is why we are saying,
Yes.
that you did not pray for BLRO demarcation.
No.
Why will you pray? Because you are already in possession.
I am in possession, but what I have alleged with the disturbance created by them.
Yes, that your possession as granted on the basis of the partition suit
Yes.
is being sought to be disturbed by them.
Now, why this thing has happened, I was also trying to inquire. The reason is this is a large land. Now, I am a cultivator. I go on cultivating by the particular cows and other things, Miller. I have to make the particular cultivation. Now, when I am making the cultivation, they are saying that this is not your portion. This is my portion. Then what happens is, Miller, when this allegation was raised before the court says very well, do not proceed further. Kindly see the order, Miller. I appeal to my lords. I appeal to my lords, Miller, for a second, Miller. to come to the order which was passed by the learned court below, which is the subject matter of challenge in the particular thing. Page 113 to 114 of this application for stay.
Mr. Bhattacharya, if you are in possession, put in possession by the bailiff, and they have been put in possession by the bailiff in execution of the final decree.
Yes.
Then where comes the next period, next
Miller,
occasion
the
for
demarcation of the particular portion of the land. Why? Because they are creating this disturbance.
the civil code
Even,
decree?
yes, Miller, this is taking place. And this I have taken the
The
instruction.
civil code decree is there.
Yes.
How does the demarcation issue
Miller,
arise?
kindly consider, Miller, we are all, Miller, coming from the cities. Therefore, we have no ideas. Now, kindly go to the village, Miller, where there are, Miller,
How can the final decree be final decree
the
execution
final
done?
decree has passed.
Then-
It has attained its finality. I am
So
not-
we will record that there is no requirement for any further demarcation.
But Miller, the disturbance created for which I have alleged.
For that we will keep that portion pending, that no untoward incident or breach of peace will take place.
Miller, which one, Miller?
The order impugned page 13th of August.
Yes, yes.
We will exclude the portion of demarcation and we will say that no untoward incident or breach of peace shall it in case police authorities will take any steps.
Miller, but Miller, I am being told that when we made the complaint, police came to the particular local. Police came to the local to see as to what is going on.
We will say
the police said that how we can say that which portion is yours, and because there is no, it's a large field.
Bailiff has put you in possession.
Miller, I say, Miller, kindly consider this thing.
they
It
are
is not that
satisfied.
particular Miller city.
Mr. Bhattacharya, if you unnecessarily say something, you also know after the civil code decree is executed.
Miller, I am not for a second saying before my lords that after the final decree has been passed, the court will see it. Unless there is an appeal, the court cannot.
At your instance, court has seen.
Miller, I say, Miller, that this has not done. What is the court said, subject to correction, that the BLLRO will demarcate in accordance with law, no untoward incident or breach of peace takes place.
You didn't ask for that. That portion,
yes,
the demarcation part, you didn't
No,
ask
I did not. I did not
So-
make a
so-
prayer
so-
for demarcation.
Correct. So if we modify the order saying
Yes.
that the demarcation portion will expunge,
but
insofar as the police authorities to keep a strict vigil, if you are disturbed, police will act. We'll keep that portion.
Very well. I leave it to my lords. Again, my lord, I know that what will be the fate, because this will go on and they will start.
What is your prayer before us? Tell us.
My prayer was not to create any untoward incident. Kindly see, as I have told you, lordships, my lord,
We are giving that order to you.
I say that kindly, at the risk of repetition, my lord, kindly see, my lord, that
Page 89.
at page 89 of this application for stay, not to cause any continuous disturbance, illegal and wrongful activities, criminal intimidation and threat in peaceful possession, cultivation and harvesting the petitioner's land. Page 80, page 90, this is a prayer. Kindly protect my this portion. I do not say demarcation, I leave it to the court. I leave it to the court.
Your position on cultivating since 1999.
The way the order has been passed, as if, my lord, they are claiming that they have lost the possession. So they have to go before the civil court. Where fresh
So
demarcation.
you are not disputing that he has been put in possession of 5.71
Yes,
acres of land.
that has been, my lord, he has been put according to the civil court's degree. That has been according to the civil court's degree.
So we will ask the police authority to protect his possession.
Yes.
And
yes,
we
my
will
lord,
say,
we are not,
and we will say that there is no further requirement for demarcation. Finished.
my lord.
But so far as my prayer is concerned, kindly consider that.
Which prayer?
So the prayer which I have shown to my lords at page 90, page 90, 91. I said that permit me to harvest the paddies from the field. This particular thing they cannot in any way obstruct. Page 90 and page 90.
In their portion, my lord, in their portion, they are entitled to. They are encroaching upon our portion and saying that I will harvest your crops. Because, my lord, what has been tried to be, my lord, canvassed before the court, my lord, is loss of possession. What he is, my lord, my learned senior friend is now trying to canvass before your lordship. And if there is any loss of possession, my lord, they have to go to the civil court that this is the degree we are possessing by way of court's degree, this part of the land, and we should be given that part. My lord, now they are coming into my position. We have harvested, my lord. They will take away the crops.
Since 1995.
তুই একটু চুপ করে বসবি ভাই।
Which portion are you possessing?
My lord,
which portion are you possessing?
My lord, kindly sees.
This has to be shown from the decree.
HT application degree কোথায়? My lord, the lands.
Very good. We need not go into that.
That is not
in terms of the final decree.
In terms of the final, because bailiff has already given the possession to the respective parties.
Listen to
My lord.
the present appeal has been preferred. Telling Yes.
Your Lordship, item number 11 to 14, may I have some precedence? I have some urgency, Your Lordship, some precedence.
Pardon? Tomorrow we will.
11 to 14.
Tomorrow.
If it is
today we at
kept
2
on the
PM
top,
we have
Your
a-
Lordship,
eh?
if it is kept on the top.
That we cannot ensure, we will take it up.
Yes.
আমি আপনাকে দিয়ে দিই
The application can say
ওয়ানটা কোনটা?
My surname has been changed by my lord's order. My surname has been changed.
Remind us tomorrow when we sit.
No, this matter.
Oh. You have degraded from being a Brahmin.
Yes. Because I am appearing in OBC matters.
We will correct it.
But maybe file the affidavits as directed by your lordship. The affidavits are ready. Of the commission, my lord. I appear for the commission. This is, my lord, for item WP number 111. 111.
Mr. Mukherjee, where is your name?
Kindly see the 6 May 2025.
6 May 25 years.
Chandra Das, what's the state of West Bengal? Have you not got it?
This 119, no 132.
Subir Shankar, Kishore Dotto, then.
Eta 111 chole gel.
Oh.
Eta
Your name has been left out from.
No, my name is there, but
ঠিক আছে
surname has been changed.
আরেকটা কি
We don't
আছে?
find your name.
119.
We don't find your name, Mr.
This is the honorable second judge's
What can you see?
119.
Kishore Dotto, London AG, colleague, Priyamada
this
Singh
is-
for the state, then Mr. Tapan Dotto.
132, third one.
Have you got it?
So yes.
132. 132.
Oh, it should be Tapun Mukherjee.
Mr.
132.
Mukherjee was just now telling me the Chakrabortis are not Brahmins. This is poetic justice possible.
You take up the issue outside the court.
This is possibly poetic justice.
If it had been possible for me, I would have taken it up.
Just I've got information that 100-point roster has been published on 13th of June 2025.
13th of June.
But so far as my lord commission is concerned, my lord, we are filing affidavits in all the matters. And pursuant to your lordship, may I just inform your lordship, pursuant to your lordship's directions, we have commenced the process of receiving applications. Surveys are being done, and we are about to commence the hearings also. But there has been 7 respondents in the fresh batch. 7 respondents. And the newspaper publications we have made in my lord Bortoman, Ajkal, Proceedings, then my lord Statesman, English, Times of India, then my lord there is 3 Hindi newspapers, and also my lord Siliguri edition, so to take care of the North Bengal editions, and Nepali also. And my lord also, my lord, your lordship was, all this is there in the affidavit. Your lordship will find, my lord, we have what we have done. My lord, we have given separate headings for separate, my lord, issues.
Given copies?
Yes, we have served. Copies have been served.
So what further prayer you are wanting to make?
There is an interlocutory application that's been filed.
Yes.
After the passing of the order by this honorable court on 6/5/2025, 5 other notifications have been issued during the pendency of these writ petitions, each of which have been placed before this honorable court to contend that they fall foul of the parameters which your lordships have held to be within the jurisdictional confines of the WBC. Each of these notifications now has the effect of altering the schedule that your lordships have struck down. There is no legislative measure yet, but these are now lists notified under the WBC Act of 1993. The consequence is now that there will be a legislative measure to reincorporate it into the schedule in the 2012 schedule, which may have to invite another legislative intervention. But I need your lordships time to indicate to your lordships that the entire process that's been undertaken while the writ petition is pending here is directly in derogation of what your lordships have held to be a compliant procedure with the requirements of law, with the requirements of the judicial mandate in Indira Sone and the rest of the judgments. I will indicate to your lordships as to how each of the decision-making process and the recommendations that's been made by the West Bengal Backward Classes Commission falls foul of all of the parameters which your lordships have indicated are necessary primary ingredients of a factual investigation. For once, there is no determined criterion published on what would constitute the social and educational backwardness. All of the data that has been placed before your lordship in the 700-odd page affidavit, except the public advertisements, rest of all the information is in the exclusive knowledge of the commission and the government. None of that has been placed in the public domain for any of us to participate meaningfully in the public hearing exercise. Each of these findings now will reinvigorate Schedule 1, which has been struck down by this Honorable Court, and there is a re-arrival, if I may say with respect, the reinventing of the wheel, albeit with the same flaws which your lordships have found to be inconsistent with the principles of 14, 15, and 16. If these notifications of reintroducing 140 communities again, as between interspersed between category A and category B, have the effect of being incorporated into the schedule, we will have the same situation without following the procedure as indicated by this Honorable Court. So we have a revised process purportedly in pursuance of the liberty granted by the Honorable Supreme Court, but continues to be non-compliant with the foundational requirements which your lordships found are necessary for any justifiable action as of fact and as of law. I'll only take about 15-20 minutes to point out as to how each of these flaws vitiates the notifications which have been issued, which is now a process concluded as far as the fact inquiry is concerned. Now the list.
Sir, how can we, you have to point it out through by, they have used a substantive affidavit in terms of our earlier.
Yes. As on date, my lords, what is now going to happen is there is a direction by a single judge of this court as to how to continue with the recruitment and admissions, which will have to be in accordance with the pre-2010 notified backward classes, which is required to be the guiding force. Now, if this supervening circumstance of finding 140 communities, which is a rehash of the same communities, without any supporting data, will have the state to conduct admissions or conduct recruitment on the basis of these new notifications while the writ petitions are pending here. Either
legislation is formally introduced, won't the, I mean, the notifications are just indicative, isn't it?
Well, it's in my respectful submission, the legislative intervention that is required now, especially after your lordships have held that the provision for making reservations is now occupied by the 2012 statute. There is a consequential legislative amendment. Either they will reintroduce Section 5, or there will be an amendment to Section 2H, which your lordships have struck down. But it is only a legislative consequence which does not involve any other fact determination, which is concluded here. The fact determination which will warrant a consequential
that will be deliberated in the legislature.
Now let's kindly see as to what is already accepted in terms of how the list, which is indicated as the list for the.
There are two aspects. One is as regards the recruitment and the admission.
Yes.
Yes. To that effect, a single judge has passed on.
Yes.
From the affidavit which they have given you copy, does it
Yes.
appear to you that they would be inserting this?
Yes. I will indicate to your lordships as to how it is a process in imminence. There is a communication which has been placed towards the end of the annexures, which says the Backward Classes Commission's report has been placed before the legislature for debate. But what was required to be done in pursuance of the operative directions issued by this Honorable Court was, before it could be notified as a list under the Backward Classes Commission itself, it has to be placed before the legislature. But the government accepts it now. 140 communities which have incidentally been part of the schedule have come back to being notified as backward classes lists, albeit for the 1993 Act within a period of 45 days. And all the insignia of it having been targeted at a particular religious denomination is writ large and continues to be writ large. And as of today, the sample size that is, the data that has been frozen, your lordships have held There has to be a contemporary data. There has to be a quantitative and empirical and normative analysis of the surveys which come to be placed before the Backward Classes Commission. And then there has to be an application of mind on what are the figures available of public employment vis-a-vis these segregated social groups, and then compare it with the existing groups that are there and arrive at a process of reservation. Your Lordships are aware, between 2010 to 2025, apart from the initial 64, what was indicated again was an addition of 77 communities which have come to be by reason of 5A, and 37 communities which have come in by reason of the power to amend the schedule under section 16, both of which have been struck down. Now, all of these communities have come back on the basis of this following survey. 50 households per district have been taken as a sample size for each of the communities, and 1100 households have been verified for coming up with a data which will have the effect of providing for reservations to 35% of the population of the state of West Bengal. The 2011 census, my lords, which is the freezing point as was considered earlier, would have the figures of the population at about 8.5 lakhs and the targeted religious population of a particular denomination to be at 27%. Now, by projection of what could be done as a statistical imperative, it has gone to 10.45 crore, and the population percentage of this targeted religious community is about 30%. So we have 1100 households straddling 140 communities, traversing 37 to 40% of the population to be provided with 17% of reservations, when admittedly the state's population figures are not available. The population figures of each of the communities which has now been found entitled to be recognized as SEBCs is not available. And the data which is collected in pursuance of the sampling survey, I will indicate to your lordships, is on the basis of enumerated parameters which does not satisfy looking at non-Hindu occupational groups, as has been pointed out by your lordships and Indra Sawant. Now, this forms the statutory basis for inclusion into the lists under the 1993 Act. May I now invite your lordship's attention to the 1993 Act.
Without availability.
Give me the 99.
Without availability.
This application.
No, my lord, it has been served only last week. I think on Friday or Thursday. Friday. My lord, today my learned friend is making these submissions. My lord, he may make his submissions, but I don't mind. But only one point I want to make out. I have filed a comprehensive affidavit. Each and every issue which is sought to be raised today by this interlocutory application has been dealt with specifically in my affidavit. If my learned friend says that he does not wish to file any counter or the rejoinder to this affidavit, that is one thing. But if my learned friend wishes to proceed with the application, then I would be obviously relying on this affidavit, which is now part of the record and which has been served upon them.
Are the issues raised in
Absolutely, each one of them, my lord, each one of them,
in your affidavit?
each one of them. But if your lordship, my lord, may I just make it
Supreme Court hearing the matter.
Supreme July. Next month.
Next month, which date?
July 2025.
Page 44 of our affidavit, my lord, we have annexed the Supreme Court order. On the immediately on reopening, my lord, subject to correction, my lord, business, page 44 of our affidavit. Any of the affidavit your lordship may kindly take.
It is directed to be listed on a non-miscellaneous day in July 2000.
That's an NMD. That's an NMD. That will be taken up, obviously.
So I will only be relying upon the affidavit filed by the Backward Classes Commission. For the purposes of the present submissions I make, I don't need a rejoinder. I will rely on the information furnished by them, the pleadings and the documents filed by them to indicate without having to contest any of the factual premises or the conclusions they have arrived at by way of a rejoinder.
But can we go into that at
Yes.
stage?
Yes, at this stage.
When Supreme Court, they went to Supreme Court, there is no stay.
Now kindly see the reservation.
There is no stay, sir.
Yes.
So today they will place the report before the Supreme Court.
Yes, we are placing that.
The ground before the Supreme Court that once the order has not been stayed, question of this entire procedure is a nullity because it is in violation of our order.
Yes. Now kindly come to the interim order or the reserving of the liberty order of the Honorable Supreme Court and the Backward Classes Commission's understanding of the liberty that has been granted as has been stated in the pleading.
Sorry, I'm so sorry.
Now kindly come to page 47 of the affidavit in reply filed by the Backward Classes Commission.
Yes.
Opposition, sorry, affidavit in opposition.
Which matter? Which matter?
In 111. In
111.
writ petition number 111, Amol Chandra Das. Now the Backward Classes Commission understands the liberty to be unhedged by the pendency of the Supreme Court proceedings as far as revisiting the entire matter is concerned. I will indicate to your lordships from the pleadings of the Backward Classes Commission, and I will place it before this honorable court that this is an exercise without prejudice to the contentions there, but in compliance of your lordships' directions in the division bench. And if they maintain before your lordships that it is in compliance with the division bench's recommendations, that SLP for the purposes of this exercise may not be relevant, because they are before this honorable court in pursuance of my writ petition saying we have taken whatever contentions we have taken in the SLP, but without prejudice to those contentions, on the basis of the advice received by the Backward Classes Commission from the learned Advocate General, they have decided to comply with your lordship's directions to proceed with a revisiting of the entire process. Now, if this is a revisiting of the entire process, that earlier identification having been eschewed, if this process is to result in the notification of the communities for the purposes of the schedule or for the purposes of public employment, the Supreme Court's canvas or the contours of SLP would not comprehend the present exercise which has been done. That is their understanding in the petition.
Well, without disturbing my learned friend, is it the contention that compliance of your lordship's order makes the SLP infructuous?
No.
Unfortunately, that is not the law.
That is not the law. But
therefore, everything is open before the Supreme Court.
Now, my lords, therefore,
and that is why the Supreme Court was informed.
I'll just make
because it creates an impact on very many things. My admissions, the other recruitments, promotions, everything. So we cannot, everything cannot come to a standstill. Therefore, my lord,
may I just make one submission?
Now,
therefore, everything is before the Supreme Court. If my learned friends have any grievance, they have very many grievances. let it, my lord, await at least till the end of July.
Now, my lords.
Malala, may I
I've
one
understood
one
what my
submission,
senior
one
friends are
submission.
saying.
1 minute, let him.
Malala, may I make one submission? Your lordship was pleased to pass an order on 6th of May to continue with the process. Having regard to the law laid down by your lordship at paragraph 360 of your lordship's judgment, we are complying with your lordship's direction. Now, my lord, if your lordship takes the applications, I do not want to argue on the applications without any affidavit. My lord, naturally, because my lord, pleadings are not complete. Even if we take the applications as they are, my lord, these applications are nothing but application for modification, variation, or vacation of your lordship's order. Nothing more than that. My lord, whatever, this is a second attempt made by the petitioners to stall the process. We want to comply with your lordship's direction. Obviously, my lord, the SLP is pending. We do not know what will be the fate of SLP. My lord, it is an argument of no, my lord, subject to correction by my learned friend. Perhaps this argument may not be correct because Supreme Court may either confirm, Supreme Court may also modify. So whatever reports we will be submitting, that would be a relevant material before the Supreme Court when the matter next comes up before the Supreme Court. Obviously, my lord, we are bound to place everything before your lordship because we are now in a process of complying with your lordship's direction. We are doing so.
There is a bit of a gray area, Mr. Mazumdar.
Right.
Whether the consideration or consideration of the propriety of the process undertaken by you
Absolutely.
will be examined by the Supreme Court or this court is what is being now, I understand,
But
being argued.
May I make my stand very clear? May I make my stand very clear?
Yes.
My stand is that I am complying with your lordship's direction. My lord, I am bound to, my lord, follow your lordship's direction and any further direction to be issued by your lordship. I am also bound to place all the material before your lordship, which I have tried to do so in my affidavits which I have filed today. So, my lord, the primary material is now before your lordship. There is no rejoinder to my affidavit. Now, my lord, this is now a second attempt. Now, as I pointed, I don't want to repeat myself. But, my lord, today, unless and until your lordship has the occasion to go through my affidavit and go through their rejoinder or their rebuttal. If there is no rebuttal, that is one thing. If there is rebuttal, then it is another thing. My lord, your lordship, perhaps subject to, my lord, I will stand corrected, will not be in a position to assess the entire process and to examine whether we have carried out the process in compliance with your lordship's directions or we have acted in derogations of your lordship's direction.
Mr. Counsel for the petitioner, what is it that
15
you
July
are
is the
praying
next date.
today?
Yes. Now, my lords, if they have stopped short of giving effect to their fact finding and placed the report either before this honorable court or the Supreme Court, one set of consequences would arise. They have acted on the fact finding done in pursuance of the liberty and have modified and amended the statutory lists under the 1993 Act. So therefore, if it is of no avail to argue for me today, I am asking myself a question. The admission schedule for the current academic year is on. The recruitments have been put on hold. Would the state government act on the present included list purportedly in compliance with your lordship's order? Or would the, I'm asking myself the question, or would the state be complying with the Supreme Mandal's order where the learned judge of this court has held that you have to revert to the pre-2010 notification for the purposes of conducting recruitment? It can't be that your lordships are disabled from scrutinizing it. It can't be that the Supreme Court will see it in July 2015. And in the meantime, a fait accompli will be provided to me where the newly reinvented, re-included communities.
No, they have given an undertaking. They will not do so.
No, that was, my lords, kindly see the undertaking in the contempt case, which is what your lordship's referring to.
That in all the departments,
Yes.
they will not be proceeding with any further.
Yes. Now, my lords, the admission schedule for the present academic year is in June. Now, if they are to comply with Supreme Mandal's order, then we are all happy with the consequences.
That has not yet come today.
Yes, my lords,
It has not yet come.
Yes.
That what will happen, state has not disclosed, subject to what you say. What you are arguing is that by keeping the matters pending, they would be inserting the new set and they will be throwing it upon the pending selection and recruitment process.
Yes. Now, if that my lords, if the state were to say that this is only a revisiting exercise. So
Interim protection you want.
I am
for?
saying that these notifications which have the effect of reintroducing the communities your lordships have struck down shall not be treated as OBCs for the ongoing admissions in 2025 because now I am just indicating to your lordships, it is not a pure and merited simple exercise of fact finding. They have placed it before this honorable court to abide by the verdict, or they want to place it before the Supreme Court and await adjudication. They have gone a step ahead and actuated the statute by accepting these recommendations and notifying the lists. Kindly see the CAN that I have filed. Kindly see what is left for the state to do is to bring in a consequential 3-line legislative amendment and present a fait accompli to me. Your lordships have said under 2H of the 2012 Act, it is read down to be in consultation with the Backward Classes Commission. So the Backward Classes Commission is consulted by the executive government for the purposes of incorporating these communities for the list under the 1993 Act. So the same list will be actuated into the 2012 schedule and we will be shown.
Subject to approval by the
Legislature. Now, in my respectful submission, these findings will be the legislative fact for the purposes of the proposed legislation. I am not interdicting legislation. It might come whatever stage it has to come. But this is not a pure academic exercise which has been undertaken by the state. It has resulted in a statutory consequence of the statutory list of OBCs being amended. As to whether this could have been done on the factual premise that has been undertaken, purportedly in compliance with your lordship's order, and there is no remote compliance, I will not have to seek to any rejoinder. I'll rely on the documents filed by them. I'll show their pleadings, I'll show their data, and I'll show each one of them is in direct violation of the formulations of your lordships in para 260, para 280, and 360 of the holding in 22/5/2024. This is not a vacant exercise trying to bide their time. It has resulted in a statutory consequence of the list under the BCC Act being amended. Now, I am affected because it alters the landscape of admissions as far as I am concerned or the affected students are concerned. Now, kindly see the consequences. Well, your lordships have already dealt with those submissions as to whether a PIL could be maintained. I will indicate to your lordships that the same circumstances your lordships have indicated to hold that the PIL is maintainable in these matters continues to writ large. There is no publication of the primary data. There is no publication of the social enumerating factors. There is no publication of any of the applications filed by any of the intending communities. There is no publication of the Backward Classes Commission's reports, 4 of them. I am told, I'll indicate to your lordships, they are not even cursory. Your lordships have said it is a deliberative democracy. There has to be an application of mind. I'll indicate to your lordships that there is not even a lip service of consideration. 4, they have arrived at re-quantifying the reservation from the existing 10% to 17%. Now, that is an activity relevant for 2012 Act also. There is no state population figure. There is no population figure of any of the communities that have been identified. There is no contemporary figure of public employment and the people who have occupied those positions. 2014 is the freezing data. Between 2010 to 2025, 140 communities had the benefit of reservations. The data would alter. There is no data. But the state has decided that it will have to be at 17%. Your lordships have said, in the opinion of the state, adequate representation will be.
That has not yet been done.
That has been done. That has been done. I'll place before your lordship.
17%.
Yes, I'll place it before your lordship. I'll place it before your lordship. Absent population figures of everybody, absent public employment figures of the figures now included, I would ask myself, it could have been 25%. It could have been 33%. On what basis was it reduced to 17? The incidental replication of Section 5A of the Act. If they have to validate their action, they have to remove the basis of the judgment or they have to await the Supreme Court ruling. They can't reinvent the wheel and recause the same consequences. My lords, I'll just take 3 minutes of your lordship's time to read 5 notifications they have issued, which is of some statutory consequence. They have not said that they won't be acted upon for the present year.
Sir, just tell us, suppose today, before the Supreme Court hears, whatever faulty method they have adopted, in derogation to our decision, suppose today they said they take a decision that yes, we have amended the schedule on the basis of this commission recommendation, and tomorrow all pending selection processes would be guided by this new data.
Yes.
That situation has not
No,
occurred.
that is the situation today.
Where from we will find.
My lords, your lordships will see as to what is stated in the pleadings in the commission. I will indicate to your lordships as to what are the consequences arising from these notifications and see how imminent that process is, because they are not saying that the commission.
So then, sir, we have to give them an opportunity to reply.
My lords, as of today, if your lordships just gives me 3 minutes time, I'll indicate the ramifications of the exercise and its culmination in these notifications. If your lordship's conscience is satisfied that what is now required is the imminent process of legislative notification of these processes, then we are looking at an inevitable consequence to be provided as a fait accompli to me. I am not seeking interdiction of a legislation, but I am saying the factual predicate which is underlying the process is so flawed.
Where they have said that they will be implementing this in the.
Well, it's that in this particular, that is not stated in the writ affidavit. It is not their case now that the present admissions in 2025.
That is not their case now.
No, I'm subject. Nor is it their case.
The one single judge has said that you follow the 66.
Nor is it their case now that they will be following the pre-2010 classification for the present purpose, because the pre-2010 classification is also amended now. 64 out of the 66 communities are reintroduced. They are interspersed between A and B. The entire landscape of the OBC figures has now changed. This is how far-reaching the fact-finding purportedly innocuous exercise has been left. May I just indicate to your lordships?
That legislature has, through the legislature, it had been done.
Yes.
Huh?
Well, let's kindly see what has been done in relation to pre-2010 classes now. Now, kindly see the notifications. I'll just take 5 minutes. Kindly see the notifications which have been filed.
My learned friend takes your lordship
Along
to
with
the
the
It should get an opportunity.
I'll just indicate your lordship.
It has not filed any affidavit.
1 minute.
Because the entire fact situation, I have a duty to
And
place
how
before
does
your
this
lordship.
affect
May I just point out? I would request my learned friend.
Thought for. None of the petitioner had filed any objection. I'm told only one petitioner had filed an objection but did not turn up for the hearing.
From 29th April till date, hearings are on. None of the petitioner participated in the public hearing. My lord, may I just indicate to your lordship? Now a submission is being made that these public hearings, my lordship will kindly go through their application.
I will show.
The application says that it was not properly publicized. On 6th of May, we informed your lordship that it is being publicized. Well, the regular notices are being published in the newspapers and they are free to participate. They did not participate. What they did, my lord, one of the petitioner in Puravidas petition, some Novendu Bhattacharya, something like that, that gentleman writes a letter on 20th of May that I wish to be heard. He doesn't attend the hearing. He says that I wish to be heard. Then, my lord, the affidavits which we have filed, my lord, submissions are being made, that reports are nothing. Reports are basically, there is no rationale behind the reports. For each and every class, I will not use the expression community. For each and every class, there is an exhaustive report.
There is none.
Yes, please, my learned friend, I will request my learned friend to bear with me. We have, as a sample, we have provided 2 of such reports. If your lordship directs us, by tomorrow we will produce another 49 reports.
Place the reports.
And my lord, these reports were placed before the legislature as informed by the state legislature to us, because copy was forwarded. And the state legislature has taken some resolution, but that is not within our domain. That is for the state to submit. So, my lord, whatever reports were there, whatever notifications have been issued, my lord, I am not here to defend. My lord, I am here to defend the basis of the notification, because I have supplied the basis of the notification. My recommendations have been accepted. If my recommendations have been accepted, your lordship would have to, my lord, for each and every class. My lord, naturally, your lordship, that's a fact-finding exercise. Lordship will definitely do that. My lord, we are not shy of that. But where is the averment anywhere in these applications that this community could not have been conferred the class of OBC A or OBC B? Your lordship pointed out in your lordship's judgment that this has to be a dynamic data analysis based on quantifiable and identifiable data. As a result of this dynamic data analysis, some classes which were placed in OBC A are now in B. Some classes which are placed in OBC B are in A. My lord, I am not here to, my lord, this is not, my lord, a religion-centric exercise.
We have struck down the very basis of A and B.
Yes.
How you are
No, your
reinventing
lordship,
that?
your lordship has, no, your lordship has not done.
24
No,
September.
your lordship was pleased to strive, pleased to hold that it has to be done. My lord, the process was illegal as held by your lordship. Your lordship has not held, subject to your lordship's kind consideration, this subcategorization is not permissible. Subject to correction, my lord, I will stand corrected, my lord, I will stand corrected. My lord, whatever I have read, your lordships have held that it was all state in the earlier round. Because state appointed the surveyor, state did this, state made this recommendation.
Yes.
So, my lord, so consultation, that process of consultation has been, my lord, concluded in some cases. In 71 cases, 76 cases, this process is over. I believe notifications have been issued by the state and placed before the state legislature. 41 cases are still pending, are still undergoing, which also has these, my lord, these classes. Then, my lord, another set of classes are being considered pursuant to your lordship's direction. We have tried to follow to a T whatever your lordship had directed. My lord, these allegations are vague and too wide and too reckless. Too wide and too reckless to be made in a PIL just for the purpose of stalling a process.
We are not.
And kindly hear us, my lord. We are not shy of hearing. Kindly allow us to use an affidavit within 7 days. We'll file affidavit. We'll come back to your lordship and get the matter heard.
We are only saying.
Yes.
Then, we have no powers, or we should not normally exercise powers on a legislative process, and
Yes.
we don't do it.
Your
We
lordship.
religiously abide by that.
Yes.
Because the theory of separation of powers is very important.
Right.
At the end of the day, you have placed a certain data before the legislature for its consideration.
Correct, my lord. Correct.
Now, the legislature may accept, may reject, may modify or do whatever it deems, or remand matter back to you. That is the wisdom of the legislature.
That's the legislative affirmation.
That is the wisdom of the legislature.
Right.
Now, at this stage, there is good, bad, indifferent, an application from their side, questioning some issues or whatever, bald or otherwise.
Then, my lord,
and there is no response as yet to your affidavit in opposition.
Absolutely.
Now, unless the pleadings are complete.
Yes, my lord, kindly do that. Kindly
Now,
give us a short date.
Time we suppose tomorrow.
Yes.
In the process of these 7-8 days, unlikely 7 days or another 3 days, 4 days.
I cannot answer that, man. I cannot answer that.
It is unlikely that the legislature will just pass everything and implement the data. Is that what
the legislature has passed? It has been passed.
Placed before the legislature, and this has been passed. These are the documents.
My lord, advertisement has also been issued. Advertisement issued, everything has been started. Even today,
My
lord,
even pending
the advertisement has also been issued.
But it has been laid before the legislature, and legislature has approved that. But that is the process which has been laid down by the court, and which is.
Was it placed in the form of a bill, or was it placed in
No,
the
no.
form
It has
of an
been.
amendment
It has been.
to the act?
It has been placed or laid before the legislature.
What has been laid before
In the form of a report as per the statute. As per section
93 or 2012?
93.
93, of course.
There is no action under section.
Of course, 1993.
So as of now, there is no action on the 2012 Act, which is the guiding legislation.
But probably they are not following that act.
No. Not probably. Let my learned friends say that it has not been followed, or the proper law has not been followed. Why probably?
Why they are not?
To have a 2012 Act, we understand and we approved. We read down portions of it.
Yes.
We struck down portions of it. That is the legislative. That is the legislation you will follow to declare these classes, whatever. Now that act is yet to be done. That action is that what we understand?
But everything has been done.
Which means, has the bill been passed to amend the 2012 legislation?
This would not be required in terms of the act. It has to be laid before the legislature. It has been laid before the legislature. And
What has been laid?
The report. The
Report
report
of the commission.
of the commission
And accepted.
and accepted by the legislature.
The legislature has accepted
Accepted
the
it. Yes.
report.
The report.
And based on which you issued a
Yes.
administrative order, or is it a legislative
No,
order?
we have, Milord, we have issued the administrative order as well as, Milord, what is they called roster. 100-point roster has been amended.
Now, Mr. Dotto, here is where we are a bit concerned. Because in our judgment, we have said that the parallel powers between the legislature and the executive cannot coexist. They supplement one another. They complement each other.
Right.
But one cannot supplant the other.
Yes.
That is the essence of what we have said. Now, we thought, I mean, based on our understanding is, if you want to introduce a class as OBC or OBCA or OBCB, you will be presenting an amendment to the bill, a bill before the legislature. It will be debated and it will be passed by the majority to bring into. So you are using the 93 Act to
subject to correction.
which is an executive power.
Subject. I'm sorry.
This is the state's action. Mr.
Milord, your lordship may kindly take
Your judgment.
my lord's judgment, which
Directions.
is.
Directions.
আচ্ছা, এটা কোথায় পাবে?
In the affidavit, first annexure, page 38 on.
But I'm told me it's in the affidavit of my Mr. Muzumdar's client.
What you are showing us?
Milord, in terms, your lordship.
Paragraph
This is
of the
paragraph.
order of
It's a
the-
paragraph কত রে?
Paragraph 356
So
of the
that is
judgment.
Direction.
Direction.
356 is the
Your lordships have held that the field is occupied by legislation, there can't be an executive power. And that is the law. And if, my lords, by a detour, without even amending the provisions of the 2012 Act on the basis of the revised exercise, they have found out an instrument of getting the same consequence by just amending the list under 1993, then they are in direct violation of what your lordships have held.
No, is it a cabinet decision or a decision?
It is
of-
an the cabinet decision was there to accept the recommendations of the BC Commission. They have acted upon it, issued.
We have not said so. We said that it
has to be placed.
before the
Nothing.
legislature.
Permit me to place it before you.
That is the direction. We have followed it.
No, nothing has been done.
Yes,
Nothing
let
has
us-
been
let
With
us-
my lord's permission, can I just supplement Mr. Sriram's argument with one submission?
You had your turn.
I have not.
Let us.
With my lord's permission.
Your lordship may kindly take me at page number 190.
Page 238 of the
এখানে কত হবে? আচ্ছা,
page
page-
238 of the affidavit.
Page
No, you are
38 of the affidavit
very good.
of Mr. Muzumdar's client.
My lord.
Are the portions of
Volume.
the directions of your lordship's milord.
1 minute, madam, just hold on. We'll get
Grateful,
back.
ma'am. Will grateful.
Who are you appearing for?
My lord, I am supplementing Mr. Sriram's arguments. I am appearing in the third connected matter, which is Purbi Dash and others versus State of West Bengal. Writ petition 132 of 2025.
Kindly wait. We'll hear. We are hearing the Advocate General. We'll get back to you. 1 minute.
Grateful, my lord.
You are pay. You want us to come to pay?
Milord, your lordships may kindly take milord the second last page of my lord's judgment, which is page 268. 268 of the
Is
affidavit.
it 268 of the
238, I'm sorry.
affidavit in opposition?
Yes, 238.
230.
WPA 111. 189.
Yes.
Three paragraph.
Itu.
Yes, which subclause you are showing?
G. Apropos the present query of the court.
Yes.
The backward class department of the state in exercise of powers under section 11 of the 93 Act shall in consultation with the commission place a report before the legislature with the recommendation for the inclusion of new classes or for exclusion of the remaining classes in the state list of OBC. That is what we have done.
Page 685 of the affidavit.
685.
685.
So now the legislatures has approved that recommendation.
Yes.
We have followed milord your lordship's order in toto.
It's 685
কত গো?
volume 4. 685.
এখানে বের করো।
What about the section 2H and others of the 2012 Act, Mr. Dotto?
We are not acting on that basis.
This is one part of it. This is one part of it.
Yes.
Kindly come back to the directions in paragraph 2, I mean page 236 onwards.
Yes.
Now B,
Yes.
237.
Yes, my lord.
Now, this is, we said that 2F
is read down.
Government would mean the state of West Bengal in exercise of legislative functions.
Yes.
Now, second part of
Having
2H,
due, my lord, only my lord, may I complete that part, my lord?
Yes, please.
Having due regard to the reports of the commission.
Yes, and under 90.
Yes,
Under
definitely
93.
definitely having regard to the
Yes.
commission.
That we have
Yes.
followed then.
Come to C then.
Yes.
Second part of 2H, as and when may by notification of emphasis is that is struck down.
Yes.
D.
Yes.
Yes.
16 of the Act is struck down since it empowers the state executive
Yes.
to amend any schedule to the Act, including Schedule 1. Consequently, 37 classes included in exercise of Section 16 by the state executive is struck down from it. Now, if this is struck down, what we have clearly indicated is any recommendation of the commission, which was first erstwhile before our judgment came in, it was not there.
Right, my lord.
First, it has to be preceded by a recommendation of the commission. It is placed before the legislature in the form of a bill. The object is to amend the 2012 Act,
That is not there.
to bring in a legislation. That is how you did it earlier.
My lord, your lordship, may kindly take
Because
my-
you include, first there were notifications in 2010, then you brought the 2012 Act, and you said you brought in the schedules. Now we expect that the same procedure to be followed, because after all you have a 2012 Act staring in your face. If the Act were not there, if the Act itself was not there or repealed or whatever,
93 Act,
then under the 93 Act set with Article 16 of the Constitution, you could have done exactly what you have done now. But with the Act staring at you,
Yes.
could you have, without a bill for bringing these classes, it still amounts to an executive action seeking the approval of the legislation, which is not necessary. Otherwise, an executive action, if it is because the power of the executive is coextensive with that of the legislature.
Yes.
If you were introducing it by an ordinance, I can understand. But if you are introducing it for the approval of the legislature, you are required to take the recommendations of the commission, place it in the form of a bill, and then approve it. Consequently, 37 classes struck down.
Kindly see clause D, Mr. Dott.
Yes, my lord.
So consequently, the 37 classes
Right.
included in exercise of section 16 of the 2012 Act
Right.
by the state are struck out of the Schedule 1. Now, by virtue of that legislation, you have to reframe Schedule 1 and bring in the classes. But without doing so, you have issued executive orders that we are including these persons.
My lord, may I say this, my lord? Please consider both 93 Act as well as, my lord, 2012 Act.
Yes.
Yes.
Under both the acts, my lord, please consider, my lord, what are the provisions. But if copy down.
That, Mr. Dotto, we have dealt with in our
Yes, yes.
judgment.
The 93 Act.
That is why, my lord, after
Dotto-
considering, that is why, my lord, after considering the 93 Act, my lord, your lordships were categoric in coming to this finding, place a report before the legislature for the inclusion of new classes or for exclusion.
That direction alone can't be read in isolation,
course.
sir.
Yes, yes, definitely, my lord, the previous exercise
Dotto,
have to be undertaken.
under the
Right.
93 Act, you did not need a legislative process. Your powers were there under Article 16 itself. Say, after Indira Sahni, the commission came into force. The commission gave its recommendation. If the 2012 Act was not in existence, all you had to do is do what you have done now. That is, issue executive orders. We have accepted the role of the commission, recommendation of the commission.
Right.
But with the 2012 Act staring at your face, you have chosen the path of legislation for the purpose of declaring OBCs. Executive orders under the 93 Act can no longer be passed, is what the essence of what we have said. In the 2012 Act, you gave yourself the power both to the legislature and the executive simultaneously, which we have held to be illegal. We are only asking you, are these notifications going to be final, or are they going to be introduced in the form of a bill before the legislature?
But this is final.
Then,
So
then
therefore,
it is
Milord,
especially in violation of our judgment, sir.
Milord, now give me 5
Let
minutes.
us, Milord,
Now give
consider
me,
the statutes, Milord,
Yeah.
only for
So
Milord,
that-
recollection.
now,
Only for
Milord,
recollection.
give me 5 minutes for the statutes interplay. 1993 Act.
Milord, your lordship may kindly.
What is time? 93 Act, function of the commission.
It's over. 356 and 359 direct violation. It's over.
এখানে ও বললো না that it is
Yeah, they
ordinarily
can't be acting upon it.
this binding advice এর উপরে আমরা act করছি।
We have the jurisdiction to set it aside in our application of contempt.
They have amended the schedule to the 2012 Act by giving a 100-point roster. But they will activate the 1993 list for activity in 2012 roster. What is that?
It's not there.
Mr. Chagat, 1 minute. Let us hear.
Lord,
Actually, I want.
Mr. Expunging says, I am showing your lordship's recruitment notification issued showing OBC A and B again.
Very good, that is covered by the undertaking given before us.
In the
They
contempt
cannot-
proceeding?
Contempt proceeding, they have said, the principal secretary.
Giving it to the new
New
level
level.
executive orders effect.
Pardon?
Giving effect to the new executive orders.
Giving
That's the
effect
point.
for the purpose of commencing the selection process, no?
Obviously, my lord, what we in the contempt
No,
application.
Mr. Sharnal, let us, there are very diverse facts. In contempt, when you showed us that they are proceeding in violation of ours.
That's old one.
Old one.
It was passed by your lordship.
To the,
Now they have what done? They have published by executive order 100-point roster, OBC A and B, and they are now proceeding on the basis of that new executive order.
processing, how we will find? They have
Dear
commenced the
Lord, can you
selection
look at
process.
the- Can you have a look at the notification?
So why didn't you bring this on record?
This was on
Well, every day we are getting it. On and on. Can you
Sir,
have a look
I
at
have to
the
carry on with the
vacancy?
process. Everything cannot be stalled. I have to give admission. What happens to the students? But my learned friends can challenge it. I don't say so. But
Mr. Dotto, you can easily do it taking into consideration 66 OBCs. 66 OBCs we have not touched.
the other, the included parts or the newly
No,
fresh.
if it is the stand of the state that let the court say whatever they want. We will, in the taking pendency of the proceeding, we will include OBCA, OBCB on the basis of strength of executive direction. Then sorry, we have to intervene then, Mr.
May I say this? May I say this, my lord?
You are passing the buck onto the court.
No,
On
no,
one
we are
hand,
not
you are
saying-
saying that it is for the court. We are not being able to proceed with the
My lord,
election
no, no,
process.
no, my lord, that is not, my lord, my submission. My submission is, my lord, that your lordships have been pleased to deliver a judgment.
Yes.
Right, wrong, my lord, we have challenged it.
Very good.
Now, my
There
lord,
is no stay.
there is no stay.
Very good.
Now, my lord, in the absence of stay, my lord, we couldn't have, my lord, redone the process because there is no stay. But, my lord, at the same time, my lord, because of situation, my lord, the reservation policy, whatever it is, amended before, after, my lord, has to be given effect to, or, my lord, taken forward because of very many reasons. What are the reasons? One is, my lord, admissions cannot wait. Number two is, my lord,
We are not asking you.
may I say this? May I say this?
No,
my
no,
lord?
why the state is so reluctant? They are saying that no. Even if you have said 66 OBCs are there, we will not do that. We will sit tight. We will conduct the inquiry. Bring more than 500 classes again entry. This is not a.
My lord, these are, my lord, in all.
You are tussle, Mr. Dotto.
My lord, may I say
You
this?
yourself have appeared and said before us that don't worry, we are initiating the process. You are in CC of the matter. Let us come back with what are the developments.
My lord, please, my lord, do not consider it from that angle. My lord, my problem is, my lord, the matter is before the Supreme Court.
Mr. Dotto, why you are not willing to proceed with the appointment procedures and admission on the basis of what remains after our judgment, which has not been stayed by the Supreme
My lord, your lordships have been pleased to, my lord, formulate a process.
Do it for this year. Next
My
year,
lord, that, my lord, we have done. My lord, our case is that we have scrupulously followed the order or the process that your lordships have been pleased to lay down, though, my lord, it is before the Supreme Court, whatever it is.
Then we have a
Yes.
right to scrutinize such action on your.
Yes. Provide,
Don't
yes.
give effect to this executive order till we hear the matter.
Just
My
for a
lord,
period of
my lord, could I say this? My lord, my giving effect or, my lord, not giving effect, my lord, please consider this, my lord. Whatever your lordships direct has to be followed.
No,
There's no
we are
dispute.
at a loss to understand that why state is so reluctant. State says that no, we will not comply with your direction. We will bring.
But
new
my
classes.
case is, we'll demonstrate that we have complied.
You will demonstrate.
Yes.
Till such demonstration, you don't give effect to this executive.
But what happens to my admissions?
What happens? 66
Now, my
classes
lord,
are there.
please consider, my lord.
Six
My
classes are
lord,
there.
I can understand, my lord, your lordships are taking suo motu cognizance. That is one thing. But
No.
yes.
Not suo motu. We are acting on the undertaking which you have given before us. You have said that, see, our order has not been stayed. We have not jumped up on you. We have given you liberty that, all right, Mr. Dotto, when you're somebody, come with this. Today, when the picture scenario is clear that 66 is untouched by our judgment, you continue this election process.
And in the event you decide that these classes that you have selected now are upheld by us or the Supreme Court or whatever, you can hold a special recruitment drive for these persons. There are always these drives that are done on a regular basis in
My
the
lord, may I
states,
say this?
across the country.
My lord, may I say this, my lord? May I say this, my lord? Please,
And
please,
in
please.
so far as admissions are concerned, there is a single judge decision which says you follow the 66 process, 60 classes then, and you also follow the roster that was applicable then. This is only pending the finalization of these proceedings. In the meantime, you have waited for such a long time. You can't wait for 2 more weeks, Mr. Dotto.
My lord, please consider this, my lord. This is not, my lord, what has been passed by the single judgment that Supremo Mondo. But Supremo Mondo, my lord, is only confined to, my lord, joint entrance examination for 2024-25.
Now, for which reason we are saying, for the time being, there is an urgent need for recruitment in the state. In general, we understand that. More so, we understand the district judiciary. There has been no appointment or recruitment in the district judiciary since 2004. There are people who are retiring every day. Our functioning of our district judiciary is seriously prejudiced and affected. So we need urgent recruitment. As a stopgap measure for the time being, the model that has been suggested by the single bench in that Supreme Mandal or whatever it is, the case, you please follow, give us a breathing space so that everybody can bring their stand on record by affidavit. You respond to their application. They will respond to your affidavit in opposition.
We have not yet used. The state has not yet used.
No, there was no direction.
There was no direction.
Yes, Mr. Chakravarti.
I have got three things to submit. Firstly, my lord, your last.
Just.
Now the Supreme Court did not grant a stay. Supreme Court on a subsequent event allowed benchmark survey. And that being aggrieved, public interest litigations anew were filed. Then in the public interest litigation,
benchmark survey was permitted by the Supreme Court.
On subsequent questioning, they have submitted.
Supreme Court has not said.
Now, my lord, 4 writ petitions which were filed anew, challenging the process of benchmark survey. There, your lordships have been pleased to give a limited right to the OBC Commission and not to take any final decision. That is not being pressed by anyone of the learned advocates.
No.
Kindly come to paper.
That rider is not there.
Para 17 of the last order. 6/5/2025. Para 17. This is a right to issue advertisement. Invite objects.
My brother.
Last order.
Para 17. Let affidavit in opposition.
Just a moment.
Page 42 of the affidavit in opposition.
58 and today.
এটা তুমি অন্য
application.
না না পুরবী দাসের অ্যাপ্লিকেশনটা কোথায়?
My lords, it is there in the affidavit in opposition, page 42.
এটা পুরবী দাসের অ্যাপ্লিকেশনটা দাও ক্যান 1 যেটা পুরবী দাসের ফাইল। এটা পেজ
We have not filed.
Yes.
Paragraph 70.
70.
Yes, please.
Just immediately preceding paragraph 17.
Yes.
What is the order your lordships have been pleased to pass? Allowing them to issue advertisement, invite objection, nothing more. So where is this question of completing the entire
where is the said that
Para 17 late affidavit in opposition indicating compliance of the above process be filed by the commission by 19 June 2025.
You have not stopped them.
Direction which your lordships have been pleased to pass in para 14, 15 and 16, that has to be complied with by filing an affidavit. Not to proceed anew and go further by issuing notification completing the process by 45 days, about 140 casts in an indecent haste.
That is what we are considering.
But then there are something more for the Union of India to submit. Now, this cabinet, Government of India cabinet approved caste enumeration in connection with census. Now, census is included in NT 69 of list 1 of the 7th schedule. The cabinet has approved the enumeration process. Whether by or without leaving aside the enumeration process, this system can be continued. Kindly see what is the decision of the cabinet.
If the enumeration is to take till 27, everybody
27.
It will get stalled.
No question of
that has the
Then
cabinet
what
taken
will be
that
done?
decision?
Then our order can
Today allow the notifications to be placed before this state assembly and give approval which Mr. Dotto has submitted. What remains for adjudication either
it has been approved.
Either before the Supreme Court or before here. Nothing remains to be adjudicated.
My lord, I can comply with your lordship's order. Take an example, my lord. I have not challenged the order before the Supreme Court. Then also, my lord, my duty was to comply with the order. I have complied with it.
In opposition, from this affidavit in opposition filed by this backward commission West Bengal, there is a direction, opinion was sought for by the chairman of the London Advocate General, and the what London Advocate General opined. Kindly see at page from the affidavit.
I have a right to opine wrongly.
This is by dictation, not by independent action.
I have a right to opine wrongly.
348,
Now
348.
that cannot be, my lord, a subject matter of scrutiny before the court.
Correct. Page 48 of the.
My lord, one thing, my lord.
That is their opposition.
My lord, may I just, তাড়াহুড়ো করো না এখন। মানে may I just, মানে if your lordship, one minute.
Kindly come to page 340.
Yeah, just give us a moment, Mr.
348 of the affidavit filed by them.
Central government is concluding on your behalf.
No.
Don't bother.
আচ্ছা এর মধ্যে আছে। Yes, 348.
Yes, now kindly find towards the middle. What is the letter written by the chairman of the state commission? Members have expressed their deep concern about the stalemate that has resulted due to pendency of the litigations before the court of law. How can such a letter be written? Now, secondly, kindly come to the next page.
Which page is it? 460.
কোন পেজ পড়ছেন স্যার কোন পেজ?
350.
ও আচ্ছা ঠিক আছে।
On February 11, 2025, you also got it. Page 350.
350.
Yes. During pendency, he also got, as you also got, during pendency of the litigations, the office of the commission received fresh applications for consideration of status that would include some of the classes whose designation given earlier had been set aside by the Honorable High Court and are the subject matter of challenge before the Apex Court in the SLPs. In such circumstances, the BCW Department of the state approached the Learned Advocate General for his opinion on the issue as to whether the state could proceed in the matter to commence survey of the communities involved in those pending applications without prejudice to the rights and contentions in the pending application. Now, 350, kindly come. On February 11, 2025, the opinion of the Learned Advocate General dated November 25, 2024 was placed before the chairman. The relevant part is extracted below. To answer the issues, the basis of the judgments of the Honorable High Court needs to be ascertained first. The Honorable High Court came to the following conclusions. The Commission did not discharge its role in the required manner, namely to collect materials by survey or other means. Here the parties rendered its advice based on objective criteria and materials, etc. The reports of the Commission making recommendation were not promised on any adequate determining principle. Therefore, the entire thing is on dictation by the government of West Bengal. No independent power exercised by the commission, state commission. It has to be struck down on this itself.
That is a quotation from your lordship judgment.
This is the affidavit. Secondly,
My lord, may I just, my lord. Yes, my lord, kindly allow me 1 minute. No, please.
Why such introduction?
No.
They were arguing, I have not said anything.
Okay.
Then, my lord, kindly come. The question of Article 246, sub-article 4 of the Constitution. Whenever in a census proceeding initiated by the Parliament, on an Act of Parliament, under NT 69 is initiated, and a cabinet takes a decision for enumeration to be included in such proceeding, whether this abundant continuation of this proceeding and finality rests tabled before the state legislature. What remains? The Supreme Court SLP has become infructuous. The public interest litigations filed before your lordships have become infructuous. Without whether your lordships had been pleased to grant and leave to them to make a finalize the notification, place it before the state legislature, and come to a finality. An old wine in new bottle is placed again. That has been submitted by Mr. Ram, appearing for the petitioner. Third, that apart, the National Commission excluded 35 castes on the question of inclusion in the OBC.
No, what is the answer 1 and answer 2 given? Kindly come to page 353. You were proceeding on that basis. Commission asks for an opinion from the state.
The BCW department asks for an
Sorry, BCW.
Look, I am
Answer to issue number 1.
I am respectfully submitting that this is an independent procedure initiated either by the state commission or to be initiated by the national commission for determination under the constitutional scheme under Article 338B of the Constitution.
Excellent.
It's a power. Whether a state government can dictate terms, advocacy's opinion on the basis of this can be sought for, and a proceeding can be initiated, number 1. Number 2, whether during dependency of the SLP in regard to the challenge to the judgment passed delivered by your lordships, whether that can be made infructuous by issuing notification, placing before the state legislature. Number 2. Number 3, your lordships on the latest public interest litigations did not allow them to publish this notification and place it before the state legislature. On this ground, it has to be stayed only.
Madam, 1 minute.
Then,
we have not stopped them.
Correct.
We have not stopped them. They do not undertake any process.
Your lordships have been pleased to grant them liberty to issue advertisement.
No.
Yes.
We have not given. We have said that.
I am reading. The advertisement should spread awareness of the identification and survey to be conducted by the commission as to enable all classes and communities in the state who consider themselves or are backward to fill in applications in the format available on the commission's website or be identified by the commission.
Where
This is your lordship's order at para 14, the last order.
Paragraph 6 of the order.
তোমরা একই দিকে আছো নিয়ে যাও না
কনফারেন্স তো করে এসেছি
দাঁড় করিয়েছো কেন
মাঝে তুমি আছো
তো একদিকে চলে যাবে
Para 14, 15, 16. The advertisement shall be published in widely circulating newspapers that they are saying they are published.
Prime office.
14, 15 and 16.
না যদি না শেষ হয় তখন তুমি এটা দিয়ে করতে পারবে তোমার হয়ে যাবে
There is no 7-0 in schedule 2. It is entry 41. You are looking at list 1. 27.
ASG finished.
Correct. Now, my lord, after your losses or last order on 6th May 2025, we find within 45 days, 140 casts have been decided, where normally for one cast 45 days is required for survey. And what is the electronic speed, indecent haste, notification placed before the state legislature. This is malafide, absolutely malafide.
Central government saying.
My lord
Not
will hear us. My lord will hear us.
I am also appearing for the National Commission of Backward Castes. National Commission of Backward Castes, time and again. the last 3 odd
170.
years.
How many included? 170.
Not at all. Incorrect submissions are being made. But I'm sorry to say, incorrect statements are being made.
I am not submitting included. I am submitting within 45 days after your losses order on 6 May 2025.
4 months.
140
76 with respect to 76 notifications have been issued. With respect to 41, the process is ongoing. And who is making this submission? NCBC is making this submission in view of 105th Constitution Amendment. NCBC has no role to play. In view of clause 3 of Article 342A.
Let us
My learned ASG was making submissions regarding 246.4. 342A3 clearly says, with regard to state list, NCBC has no role to play. This was the scheme.
Very well.
Lastly, I submit, my lord, for the last 1.5 years, National Commission of Backward Castes is writing time and again letters to the State Commission and to the Chief Secretary. Every time there was an action that is to be replied, nothing was done. So whether this is a question of national issue or a state list or a central list 64 or 66 scope of Article 246 sub Article 4 will play come into play after enumeration decided by the cabinet under the NT69 or list 1 of 7th schedule. That is a matter to be decided. Now, when the learned Advocate General submitted this is finality, the notifications, then my lord, it has to be stayed. Everything cannot be made infructuous by an executive action. The judicial process.
Very.
And your lordships are aware, when a judgment is delivered in a judicial capacity, judicial process, when that can be frustrated, there are number of judgments of the Supreme Court in which process, not by executive instruction, not by survey, not by issuing notification. This is patently illegal. It has to be stayed.
Yes, we'll come back to you for
Item,
sir.
item number 3, my lord.
Let the commission make their submission.
But I have also something to
Lord,
say.
just one moment. May I just intervene? I just have one small submission to supplement Mr. Sriram's case. I will not take more than 2 minutes, my lord. May I?
Yes, please.
With my lord's permission, my lord. My lord, the fact is, I've heard the Honorable ASG, the Honorable AG. The fact of the matter is, this is a act, the survey that they are allegedly doing, is in blatant violation of my lord's order. My lord may kindly have 217. If the lead petition, the page would be 212, para 360. In fact, I will just say, my lord, the fact is that directions given on by my lords on the 22nd of May 2024 order categorically says, and I read, the commission must adopt a fair, transparent and just procedure. Do my lords have the page? It's 212 of the lead petition and it's 217 of Purvi Dash.
So you're reading internal page?
No, my lord. It's the one marked in pen. So if my lords have Purvi Dash, then it's 217 and internal page would be 188.
No, we are very well. Internal page of our judgment that you are referring to
would be 21212, my lord. This is page 360. My apologies. I don't have the benefit of the lead matter before me. 188. Internal page would be 188, lordship.
All right.
I will just show 3 sentences to show my lord that they themselves agree that they are in blatant violation of my lord's order.
Yes.
Now, the categoric instruction, direction rather, by this honorable court is para 360. May I read, my lord?
Yes.
The commission must adopt a fair, transparent and just procedure in the process of identification of backward classes in the state. Public advertisement, present time data, survey of the population as a whole. My lord may kindly mark this. Survey of the population as a whole, detailed scientific survey, methods and comparisons with the whole population are the proper methods to be followed. Now, my lord, the interesting part is that the affidavit in reply filed by R3, which is the commission, page 14, my lord, and I read. Page 14, they themselves says, when they are asked whether they are actually surveying the whole process, the whole population or not, they say that this exercise, it would also be an absurd and unworkable proposition that every time the commission is considered inclusion, over-inclusion, exclusion of one or multiple classes, it has to embark on a survey of the whole population of the entire state. Page 15, top. The exercise is so large, a scale could only be done logistically, a census by the central government. In fact, conducting a full-scale census would not only involve exorbitant financial costs, but also may delay timely policy interventions. On the contrary, a survey allows focused data collection and is administratively feasible as also economically prudent. Having regard to this, the commission resolved to conduct the survey using the Cochrane's method for sample size determination of the whole population, which is a universally accepted statistical method. My lord, my humble submission is Indira Sani judgment, para 798 is very, and 782 is categoric. When it comes to surveys, you have to actually survey the entire population. Para 360, my lords have made it categoric that as of 22nd of May 2024, my lords also wanted that the entire survey of the entire population ought to do it. They themselves in their affidavit in reply have said that they are not doing it. My humble submission is that, my lord, once the methodology of the survey itself is wrong and contrary to my lord's judgment, then all subsequent reports and all subsequent reports are perverse and all the entire process itself gets vitiated, my lord. It is not only, and to say that the SLP has become infructuous, my lord, is incorrect. Fact of the matter is, today there is no vacuum law. A 9 judges judgment of Indira Sani mandates the state to actually conduct a survey of the entire population. This honorable court as well has held that they must survey the entire population. The moment they do this, my lord, the fact that they are not surveying the entire population, the entire process gets vitiated. And my request, my humble submission, therefore, is that a stay ought to be granted. What fell from my lords was absolutely right. That irrespective of what the judicial directions are, the state is ready to do whatever it wants and whatever it deems feasible, irrespective of whether that is in violation of a judicial order. What did fall from my lords was what is in the interim, what is the relief that we are seeking? A, we're seeking stay of obviously this entire process. And regarding recruitment, my lord, because I know that Mr. Datta was very concerned about it. Well, my lord, the recruitments as were done before 2010 in West Bengal, that can continue for the time being. Thank you, my lord.
Very well. My lord will kindly take your lordship's order dated 6th of May. Your lordship had the occasion to consider the directions contained in paragraph 360 of your lordship's judgment. Kindly take paragraph 11. Your lordship will find this at page 38 of my affidavit in opposition.
38.
It starts at page 38. Kindly take page 41.
Yes. Yes.
My lords have got that? I'm sorry, my lord.
Yes.
May I just read out paragraph 11? This court notes that in terms of paragraph 360 of this court's judgment, dated 22nd May 2024 Supra, the commission is to conduct surveys of all backward classes in the state to ensure the benefit of Article 116(4) of the Constitution of India to all such classes and not to any particular set of classes. Mr. So-and-so, representing the commission on instructions from his client, submits that his clients are now willing to do so identify and conduct surveys of all backward classes in the state. Then your lordship laid down the guidelines, what is to be done. In view of the submissions of the commission and the directions already contained at particularly para 360 of the judgment dated 22nd May 2024 Supra, this court assumes and directs the Backward Classes Commission of the state to publish advertisements of the proposed survey and widely circulate the same all over the state, starting at the village level. The advertisement should spread awareness of the identification and survey to be conducted by the commission so as to enable all the classes and communities in the state who considers themselves, this is most relevant, or are backward, to fill in applications in the format available on the commission's website or be identified by the commission. For the aforesaid purposes, all the DMs in the state and the BDOs and the officers under them shall make all efforts to assist such classes in making applications as indicated above. The DMs and BDOs shall themselves assist the commission in identifying such backward classes. The advertisement shall be published in widely circulating newspapers in Bengali vernacular and any other locally prevalent languages and circulating newspapers within the state in respective districts. The DMs, SDOs in the state shall, through their officers at the village level, shall also spread awareness amongst the backward and uneducated in this regard. Well, this is how your lordship has explained what is to be done in terms of paragraph 360 of your lordship's judgment.
That's what we have done.
And we have, your lordship will kindly take now my affidavit, page 18.
1-8.
1-8.
Yes, please.
Kindly take page 18 for once. With all the relevant annexures, in compliance of the process directed to be undertaken by the order dated 6th May 2025 passed in the said PIL, the commission immediately took steps to direct the INCA department to arrange to publish. I'm sorry, my lord, your lordship has got that? I'm so sorry, my lord. Publish fresh notice inviting applications for the proposed survey, as also inclusion in the state list of OBCs as directed by the order of this court in the newspapers, including but not limited to widely circulated Bengali newspapers and any other locally prevalent languages and circulating newspapers within the state, in order to spread awareness of the identification and survey to be conducted by the commission so as to enable all classes and communities in the state who consider themselves or are backward to fill in the applications in the format available on the commission's website. Copies of the letter sent to INCA department are annexed. Now, Miller, kindly take Y. Each and every step we have followed. Such direction was complied with and necessary newspaper
Mr. Mazumdar,
Yes.
we have given a substantial hearing to all sides.
Right.
Only in reply, we are requested to
Then,
hear.
my lord, once I'm
Petitioner, there's only one thing we want to ask you.
Yes.
As to whether you have complied with our directions in that particular order that you have set out or not.
Yes.
Is to be tested and understood
Absolutely,
by us.
absolutely.
Are we supposed to take your affidavit as the sacrosanct final judgment?
Cannot be. Can never be.
Please give us an opportunity to have hear all sides on affidavits.
Only one submission, my lord.
But we are, if you have noted the tenor of the order
Right.
that you claim to have complied with, which we will assume that you have complied with, at least prima facie.
Prima facie, my lord.
The tenor is first to see the process that you undertake, the propriety of the process.
Right, man.
Now, in addition to that, what other parameters you have included in your surveys, we have to examine.
Absolutely.
Let us do that but then if the state jumps the horse at a knee-jerk reaction, issues notification based on your recommendations, where does it leave these writ petitions? Please tell us that.
My lord, may I just answer to your lordship's query, my lord? It has fallen from my lord that executive orders are being revived. My lord, because, my lord, in view of the...
No, not from us. It is an argument made.
It is an argument made on behalf of the...
It is still an executive order as we understand it.
Order. My lord, the commission is not responsible for issuing notifications.
So,
but my reading of the notification...
So, we are only seeing that, yes, you have filed an affidavit enumerating what steps you have taken in terms of our order.
Right.
We are required to test that. We are required to hear them, the union or whatever, whatever commission, especially the state government. Now, Mr. Dotto, we ask you this. If as a knee-jerk reaction, you issue notifications and you declare all these classes as OBCs, where does what is left for us to decide?
My lord, 2 or 3 submissions on that. Number 1 is, my lord, so far as, my lord, your lordship's orders are concerned, my lord, it is pending before the Supreme Court. Second is, my lord, I can well appreciate, my lord, the concern of the court. The second is, my lord, had we not gone before the Supreme Court, what were we left with? We were left with nothing but to act in terms of the order of this honorable court. Therefore, my lord, we, according to us, we are acting in terms of the order of this honorable.
Are we not entitled to look into the propriety of the submission?
Yes,
we will presume that you are doing so.
So,
but then, given the huge controversy that this matter has seen over the years,
yes.
Now, and also the fact that a majority of the classes struck down by us are re-included, maybe for very good reason.
Yes.
Maybe for applications received, surveys conducted. We want to see the nature of the surveys conducted. We want to see the data that was available before you. We want to see how much of the state's population, what is the percentage of the population that you have surveyed, what is the level of backwardness. And most importantly, let us assume for the sake of argument that the commission has done everything in letter and spirit of our order. Let us start with that proposition.
Right.
There is a second part that the commission is required to do, is to see whether these classes are appropriately represented in the state. Now, 1 minute, Mr. Mazumdar. We are now
done.
This exercise is also to be undertaken and tested before us.
Tested.
We just want to see it. Now, if you declare and start recruiting, and tomorrow we have to strike it down, then what will happen?
Now, may I
we are back to square one.
May I say this?
And it is not as if these classes, a majority of the classes that you have recommended, are on the streets. They have benefited from a reservation for about 15, 20 years, which we have found to be incorrect and illegal. Good, bad, indifferent, they have benefited. They are not on the streets. Today, what you are looking at is fresh recruitments and fresh admissions for colleges and universities. Admissions for colleges and universities provided for one methodology has been evolved by a single bench, which we prima facie find to be appropriate. All right. But even before we test the recruitment of and declarations of OBC, if you start recruiting, where does the leave the writ petition? They are all infractors.
Now, may I, my lord, keeping in mind, my lord, the concern of the court, address your lordship's my lord on that. My lord,
Day after tomorrow. বৃহস্পতিবার বলছি। On Thursday. Thursday 2 p.m. we keep it only for consideration of the issue as regards this notification.
well, on the issue of grant of any interim orders, your lordship will be considering day after tomorrow.
I will
Thursday?
Yes, I shall make my rejoinder application there. If there has to be other petitions which will have to challenge the rest of the reports which have been made part of, I'll complete my pleadings part by then. But kindly see in the meantime, two defenses which have been.
We are only keeping it for consideration as to whether we want to pass an interim order at all or not.
Yes.
So whatever pleadings for these applications, let us not increase the applications. Whatever pleadings are left, they have to file an opposition to your two applications. You have to file a reply to their affidavit in opposition. Please do it by Thursday. Exchange it. We are keeping it Thursday 2 p.m. My learned brother has another engagement, which administrative engagement.
Between today and Thursday, if the recruitment notifications is acted upon, I'm only trying to keep the cause of action warm.
Not to worry, Mr. 2 days, heaven and earth won't fall. And if there is anything that is precipitative that is done, we always have the powers to undo it.
17.
The date given by
Even the portal is being open tomorrow.
Let it be open. If anything precipitative is done, eventually we have the power to undo everything. Sanyal,
I
can do
repetition. I'm saying, your lordships, that we have
Don't
suffered from 2010 to 2023.
2 days more.
Now, this
Now,
is
my lord, who has suffered is not before the court.
We were before the court.
No. The
This was
person
being
suffering is not before the court.
We come back tomorrow 2 p.m.
Tomorrow.
No further pleadings required. Whatever, if you want to file in the meantime, well and good. We are keeping it for tomorrow at 2
We
p.m.
will consider the interim prayer. which
Very
has
well,
been
very
made by Mr. Dotto will be
Definitely.
making.
We will only allow Mr. Dotto to make submissions and Mr. Ram to make some further in
I'll
reply.
take 5 minutes.
We have got the union, we have got the commission.
if we are able to file pleadings, my lord.
Sorry?
If we are able to file pleadings tomorrow,
By
then
tomorrow?
yes.
No, tomorrow.
I don't think they'll be able to
won't
file
be able
any pleading by
But I'll rely on their material
My lord,
to
we will try.
travels every argument.
as you
that-
please.
Yeah.
If you can do it. Let us not do it. It is only an ad interim order we will be if at all.
If at all we want.
If at all we are satisfied, we may consider. Otherwise, we will hear it after exchange of affidavit as soon as possible.
Maybe given the liberty of appearing online tomorrow, I have to travel.
Oh, yes.
I'll seek your
No online. You have to be offline.
Anyway, most certainly.
Due to paucity of time, the learned advocates appearing for
Yes.
Applications is connected.
Okay. One more application. This is going.
additional party applications.
এই আমাকে কি অবস্থা?
Which matter?
প্রদু,
Item number 4.
কালকে আমার কি অবস্থা থেকে এতগুলো কি মারে? কি মারে?
Which matter?
No, not item number 4. It's not connected.
Item number 4 of our regular list.
No.
Regular.
They
Give the numbers, it will come to what?
The cans are appearing, my lord. The cans are appearing, the applicants therein are all participants of recruitment processes which have been initiated before passing of the judgment. Now, due to the stalling of the process, my lord, they are the main sufferers. Until and unless investigation is passed by the court, my lord, they are suffering, my lord. No recruitment for the past 2 years. Notification feedback as of
You are saying 2 years, there's been no recruitment in the state judiciary for since 2004.
set up.
Imagine their suffering.
Come tomorrow.
Hey, please come tomorrow.
ভালো সেট আপ করেছি, হ্যাঁ? ভালো সেট আপ করে নিয়ে এসেছি।
সেন্ট্রাল গভর্নমেন্ট সেট আপ করছে আর এখানে একটা